My lord. I like to mention item number 3 on behalf of N. Kumar for the petitioner. The conducting counsel is from Delhi and today, due to some personal difficulties, he could not appear.
Okay.
So matter may fixed on 24th October. I have taken consent.
Consent, okay.
Yes.
With consent of the other side, the learned counsel for the petitioner prays for adjournment. Prayer is allowed. This after ensuing long vacation.
Matter may fixed on 24th October.
We are not fixing it right now because there are a lot of matters in the first week of opening. There are a lot of matters fixed. So I'm not giving a fixed date right now. Make a mention.
Okay. Much of.
Item number 1.
My Lordship, I like to appear virtually, My Lordship. My Lordship, the grievance raised in this petition is now covered by the amendment made by the government, My Lordship. With that amendment being effective, my grievance raised in this petition is addressed, and the proceedings against which I have challenged also dropped by the adjudicating authority, My Lordship. My colleague will pass on the proceedings copies, so this petition can be disposed of, My Lordship. Now that grievance is addressed by of amendment in the law, and proceedings which are under challenge are also be dropped by the authority.
My lord, in this case, I am appearing for respondent number 3, 5, and 6, my lord.
Yes.
My lord, by the latest amendment, my lord, his grievances were addressed, my lord.
Okay. So I did not say anything. I just say that because of the amendment, this petition is closed.
Yes, one similar judgment has been passed. Same issue.
No, you don't need a judgment here. Once you say that the grievance has been addressed,
Yes,
why you need a judgment?
No, on deadline.
No.
There is no judgment, but this is only an observation.
No observation. Once there's a gazette notification, what observation will the court give?
Yes. For the convenience.
No. We don't want to put extra words. Because for that, those extra words, I'll have to issue notice here, all the sides, and then put those extra words. Brother?
But we have judgment का नहीं amendment is covered. It's in the same. Name will be different, but same one. WPC 149.
My lord, my name may be reflected in the order, my lord. So it's on the prayer, my lord.
Yes, ma'am.
Obliged, my lord.
Obliged.
Obliged. Yes.
Wait, please. My lord, this PIL is directed against Lord, total inaction on the part of respondent authorities in the construction, my lord, of this NH 415, Naharlagan to Nirjuli section.
Here, my lord.
Just a moment. I'll just point out a few things.
Should I take it up?
Yes.
No, because I am also one of the affected.
In that case, my lord, every honorable judges will be one of the affected. Everybody uses the same road.
You see, I am wearing a belt.
Yes.
Just for this road.
Yes.
Otherwise, there was no necessity.
Yes.
But for this road,
But I'm just pointing out a few dates, my lord. Administrative approval.
That road condition is really horrible.
And the thing is, my lord, it is supposed to be completed as per their own report on 7th of December this year. Only around a month left. This project, my lord, DPR envisages a flyover, two-lane flyover from Borpani to A sector, 149 pillars. They say they have completed 15, which is untrue, my lord.
No, it is flight away.
Yes, everybody
Flyover.
can see it, my lord.
No, it's a flyover.
Yeah.
Flight.
There are 149 superstructures. On the last occasion, this honorable court expresses dissatisfaction and asks them to file a detailed report, and they have not done it, my lord.
It has flown away. Who is appearing for NH?
Here, my lord, I'm appearing, my lord.
You're appearing.
Yes, my lord. Here, my lord,
Why?
I was supposed to bring out the records, my lord, of status report, my lord. But due to some misunderstanding, my lord, I couldn't, my lord.
No, you can file a report that the flyover has flight away. Any dearth of funds?
My lord.
Any dearth of funds for this road?
No, my lord, it was sanctioned, my lord. More than 496 crores.
You have filed an affidavit?
No, my lord.
No, my lord.
No, but then you have to do it. Because this is a public nuisance. Instead of public convenience,
Yes,
a road
yes,
being
no,
a
my lord.
public convenience, it's a public road.
Yes.
Either you do that, or number two, declare this as a village. In our language, we call it village pathar, where you don't need a road. Village pathar is where there is no road. It's a village field. You declare that. No, I'm telling you, this is public inconvenience.
Yes, my lord.
Even at night, yesterday night, I had gone somewhere at 9:30. I was traveling back. In the roads, wherever there are some establishments, they are unloading their trucks and all. And since near the drains, where there are private cars parked, and private cars cannot be serially parked because of the road condition. So cars are haphazardly parked, and on the roadside where there is a good road, the trucks stand there and they are unloading it. They are compelled to, because otherwise their trucks will be damaged. 10-ton trucks, 14-ton trucks. You can't expect them to be on a uneven road. There are practical difficulties. Their axle will break if they are in an uneven place and loading and unloading is done.
The thing is, my lord, despite your lordship's orders, my lord, they are not even responding, my lord. So I pray, my lord, let the officers come and explain, my lord, why are they not taking it so carelessly, my lord?
My lord, can
The
this
notice
shift
was
from
issued on
third, my lord?
23rd of July. There was an interim direction that make the roads motorable at least in terms of the agreement. They are supposed to do that. I have annexed it also.
My lord,
Thereafter, on the last occasion, this honorable court expresses dissatisfaction. Then also they are not responding, man.
may I pray, my lord, this
Why don't we just visualize?
this matter
149.
will fix on third, my lord. On that day, my lord, I will bring the progress report, my lord.
No, there's no progress report. I have seen yesterday. What progress report?
Progress report, man.
The progress report can only show more potholes.
Hmm.
Yes, last time in the road there were 1 lakh potholes. Now we have 1,50,000 potholes. Uncountable. And you see, I don't understand the fun. You dig a major part of the road and keep it like that for
Yes.
so many years now. At least 1.5 years I've been looking at it.
And they are supposed to construct 149. Man. They are supposed to construct 149 pillars, my lord. And the time frame, as per their own document, is 7th of December. That was in the, they had submitted the report in
They've
the
given
last.
you any instructions? Any instructions you have?
No, my lord.
Not at all. Yes,
This
when
was
you
the
were-
report, my lord, they submitted before
Earlier,
losses
my
on
lord,
the
there
last
was-
occasion.
yes, my lord. After this report, my lord, there was
This must be there on the record. It was placed on the last.
Oh, yes, it is there.
It must be there.
It is there. It is there.
After that report, my lord, we have not received anything.
And if they would have put it on affidavit, my lord, I would have responded. All of these are untrue, in fact. There is one major breach. We know which is the major breach. Nothing is going on there, and they say it is in work in progress. And they say 15 number of pillars have been completed.
We do something which is, which we have not found in any of the orders which the court is normally passing. You see, if you don't show before the court the timeline in which work progress should be made, you see this, the reason is that this highway crosses the town. And it's not that it's somewhere in the outskirts where you have an alternative route. In order to travel only a few kilometers, today I was late by 5 minutes. Instead of 9:15, I started at 9:20. And there was a lot of traffic in the road, just in 5 minutes time. Now, therefore, I think although the vehicle is traveling with a hyper petrol, but fuel consumption must have been 1 more liter or 2 more liters just because of 5 minutes delay. And this is only one person. Here, how many lawyers are there? About 50 of your brothers and sisters are there. 50 vehicle into 2 liters a day is 100 liters. 100 liters into 100 would be 10,000 rupees a day only for people in this room. Correct. So what we are saying is that as the public is already paying for the price escalation, without the leave of the court, the authorities will not permit a price escalation between the NHPC and this National Highway Authorities and the contractor. There would be no agreement of price escalation without leave of the court. And if the progress of the work, next date, there are 2 things required. Number 1, we will produce a bar chart. We don't want status report for the time being. Even if you give a status report, we definitely need a bar chart. In a contract agreement, bar chart is necessary to understand the milestones. Milestones means that day 1, you will have a pillar casted. Day 3, you will have the casting removed. Number 4, on day 20, this is ready for, it is set and it is ready for casting of this overhead slabs. So it is from that bar chart that we will understand the progress. A statement made in an engineering or in a civil construction, you will not understand anything. At least I will not understand anything, because you will say that 10% of the work is done. Correct?
Yes.
So if that, let us say, if that 10% of the work done, I'm saying it in normal, I give very horrible examples. One of the example is that a man is to catch his flight. He says, I'll be ready in 10 minutes. And when you ask the status, have you taken a bath? He says, no. Everything else is ready. He has not taken his bath. So will he be ready in 10 minutes? Likely that it will take 15 minutes. So therefore, we want to know not from the status reports, but from the bar chart, indicating the various timelines and the milestones. And who's appearing for the contractor? Respondent number?
Contractor manager. Contractor.
Contractor. Okay. So we are prohibiting from any price escalation without leave of the court. TK Engineering Consortium. Okay. But how do you propose to do the work? Yesterday, they were about, what do you call that vehicle, which has
Tipper,
not tipper.
Excavator.
Is it a tipper? It has a hand
excavator.
Excavator.
excavator. About 4 or 5 excavators are there in the road from Nirjuli Point to the Haiku turning. About 5 or 6 yesterday I saw. Now, what is the reason for keeping those excavators on the road and blocking the traffic? You don't do any work. At least in this 2 weeks I have been here, I have not seen these tippers performing any work.
Absolutely no work, my lord. We see it every day, man. Months and months now.
So why have you kept it? We'll ask them to be removed by the traffic department. There'll be, if you don't put it to use, let the traffic department remove it.
I'll see the instruction.
You go out and take the instructions. Why these 5 or 6 tippers are blocking the road? 2 of them are near that point, this hospital. And this hospital has a lot of traffic in the morning. Patients come. Just ask them why these tippers are lying there without any work. I've never seen them working. So yesterday was quite late in the night. At the late night, they are not working. Daytime, I never saw them working. Your very good friend here, Mr. Panging, he says that he has not seen them working. So why they are lying there? Why equipments are
Because
parked
these
on the road?
pillars, my lord, were initially constructed long time back, months back, maybe almost a year back. Thereafter, it has been lying just like that. And that major bridge, my lord, just beyond that, they are supposed to construct.
Because you
Absolutely
see,
nothing.
because you see, it is lying there only for one purpose. And that purpose is to show to the government that, well, we have man and equipment and machinery is lying on the road.
After this honorable court's order, they did some superficial maintenance of the road.
No, this road is a menace. It's a nuisance to the public.
Yes, absolutely. ma'am.
Public may not need the road at all. Don't have the flyover. Abandon it. We were comfortable earlier. I'm also a common man. When I'm not in this chair, when I go out, I'm a common man. I don't have any privilege other than what I have in this chair. And road we have to take. We don't have special, what do you call, flying lanes for us. We go by the same road. And you know, it pains at times because in our car, we have a flag vehicle. when there is a blockage, they put on their siren. And when sirens are put, all the public, they are, what you call, they appear to curse us when we move around in traffic, saying that, oh, one big man is going and we are suffering. The look of the people at this point, at this hospital point, makes us frustrated. At least me. It is painful. Yes, to the lawyers present here, do you have the same feeling when you see a flag car going by when you are in the traffic? Any such thought passes by you? Cursing someone going in a flag vehicle? It happens. They are not saying.
Lawyers may be not the honorable judges, but surely if it is a politician.
No. You see, when a car is passing, you don't know whose car this is.
And if we come this road, we are aware that this is the honorable judges that are coming. But if it is some politician, some minister, surely.
So you see, people out of respect for the court are not saying anything. But the lawyers, I think, while they smile with everybody's face, I think I am reflecting what they are thinking. Correct? So these vehicles, if you are not putting to use, remove them. At least some people can walk on the road. Yesterday, after, you see, I watch everything. Yesterday when I was traveling, in the road from that, I won't understand the places. About a kilometer away before the old High Court building tri-junction, there's water logging. And in the water logging, gents, it is very easy for them to cross. But for the ladies, you see, when our cars cross, I told my driver to drive it slow. But even at slow, it splashes water. And I've seen my car yesterday splashing water on a female who is passing on the road. Will you like it if somebody's car splashes water on you and you are traveling? Will you like it? Why you don't think of others? The road must be workable. Male people, they do not suffer much. But for a lady to be splashed with a rainwater is horrible. Ms. Bamu, am I right?
Yes, madam.
And there's no footpath. You're not even constructing a footpath so that the people can walk. At least if you're not making a road, construct a footpath.
Of late, my lord, it has not been raining. My lord is right. When it was raining, it's a chore to cross the road, especially for the ladies. It was so difficult just to cross the road.
I understand. I've seen that. Yesterday I seen that. Every day
It
we don't
has not been
notice.
raining.
But yesterday it was, yesterday there was a water logging. I noticed it. And that is also about 9:30 in the night. No. You have to do something. But Mr. D. Panging Leonard, counsel for the petitioner, also had Ms. T. Wangbo Leonard. Government advocate appearing for the respondent number 1, 2, and 3.
No, madam, 1 to 5, madam.
1 to 5. Okay. Right. For the Government of India, you're there. Your name? M. Mr. M. Counsel appearing on behalf of.
Yes, dear. M. Kato.
Oh, Mr. M. Kato, then a DSGI, appearing for respondent number 6, and Mr. T. Taring, on behalf of Mr. T. Tara, then counsel for respondent number 8. There is no representation on respondent 7. Next para. This PIL highlights the deplorable condition of NH 415 between Bandardeva to Itanagar section. Full stop. The learned counsel for the petitioner has submitted that in this EIL, the condition of the road from Barapani Bridge to A sector area of Naharlagun, which is of a length of 3.950 kilometer, a flyover is envisaged to be constructed. Full stop. He submits that only halfway construction of 11 pillars out of 147 number of total pillars have been constructed. Full stop. Accordingly, comma, it is submitted that it is impossible for the National Highways Authority of India to complete the proposed construction within the timeline of within the contract period of December 2025, right?
24, my lord.
24.
7th of December 2024.
24. With the progress so far displayed by the contractors, i.e. respondent number 7 and 8. Next paragraph. This court, by an order dated 27/8/2024, required that the status report
First order was, my lord, 23/7/2024.
Status reports were directed to be placed indicating the progress up to 31/8/2024. Full stop. The learned government advocate has submitted that she has not been furnished with the status report and therefore could not be produced before the court. Next paragraph. The learned counsel for the petitioner has also submitted that for the work, comma, the state respondents to the PWD and the National Highway authorities have not constructed a footpath alongside the said stretch of road, which causes immense public inconvenience in traversing the 3.950 kilometer stretch where the overbridge is envisaged, which causes immense problem to pedestrians, especially the ladies. It is also submitted that there are several machineries and equipments lying on the road, without being utilized for any work, which also impedes easy flow of traffic and causes a lot of traffic congestion in the entire stretch of road between Barapani Bridge to A sector area of Nahar Lagoon. Next paragraph. The learned counsel for the petitioner has further submitted that after the registration of the present PIL, some half-hearted topping work has been done in the two sides of the road,
Yes.
which is not motorable, which is still not motorable. And therefore, the traffic congestion in that area has become a bane, B-A-N-E, for the citizens. Next paragraph. Taking note of the submissions made by the learned counsel for the PI, from the counsel for the petitioner, the court has interacted with the learned counsel who are present in the courtroom, and it appears that no one is satisfied, none of the counsel present in the courtroom is satisfied with the condition of the road referred above. Full stop. Next paragraph. Therefore, the lack of the non-production of the status report in terms of order dated 27/8/2024 is not appreciated. Next paragraph. On the next date, the counsel for the Public Works Department to the chief engineer within bracket highway zone, the chief engineer highway zone, Public Works Department, Government of Arunachal Pradesh within bracket respond number 4, and the National Highways Authority of India to the Secretary, Government of India within bracket respond number 6, shall ensure that the status report of the work is placed before the court without fail. Full stop. The respondent numbers 1 to 6, sorry, 1 to 8 shall all ensure that they independently provide to the court a bar chart indicating the various timelines and milestones by which the progress of the work was required to be achieved as per the contract agreement. Full stop. They would also provide before the court the relevant part of the contract agreement disclosing the date by which the work is required to be completed. Full stop. They would also provide to the court the number of men, equipment, and machineries which are required to be available for the completion of work. Full stop. We take notice of the submission made by the learned counsel for the petitioner that there is no progress of the work for last 1 year. Full stop. Therefore, the respondent numbers 7 and 8 shall also inform the court of reasons why appropriate men, machineries, and equipments have not been put to use from the commencement of the contract till date. Next paragraph. The court is inclined to direct the respondent authorities. Respondent authorities numbers 1 to 6. Not to enter into any agreement with respondent numbers 7 and 8 for price escalation without the leave of the court. Next paragraph. The pendency of this writ petition shall not be constituted as a bar for the appropriate authorities to take a decision as to whether the contractors are at default in the completion of work and take any such measure as they may so advise, they may be so advised to ensure that the work is completed within the timeline. Next paragraph. The respondent authorities number 1 to 6 shall also inform the court as to steps, if any, being taken for construction of the footpaths, at least to enable the pedestrians to walk on the particular stretch of road, and or measures, if any, they indicate to take to enable the pedestrians to walk on the two sides of the said stretch of road, even if they don't have a plan to make construction of the footpath immediately. Next paragraph. The learned counsel appearing for the respondents shall transmit a downloaded copy of this order to the competent respondent authorities. Full stop. The learned counsel for respondent number 8 shall transmit a downloaded copy of this order also to the principal contractor, i.e. respondent number 7, to bring the order to the notice of the said authorities. Next para. In the event the status report as indicated above, along with bar chart showing the timelines and the milestones and other documents required by this order is not produced, the respondent numbers 1 to 6 shall take note that the court may pass appropriate orders for the personal appearance of the concerned officers, for which appropriate orders would be passed on the next date, in the event of default. Next para. For the delay in non-furnishing of the status report before this court today, we imposed a token cost on the respondent numbers 1 to 6, quantified at rupees 5,000, which shall be paid by them to the petitioner in person, the petitioner of this PIL. Which can be paid by way of an account pay check and handed over to the learned counsel for the petitioner for onward transmission to the petitioner for the petitioner of this PIL. Next one. List on. Now tell us the date.
Eviction minor, because
You tell us date, we give you on that day. We are not in a hurry now.
28 minor, October.
28/10/2024.
Okay.
Lordship, I may be wrong, but I heard post happening in court correspondent number 6.
1 to 6, yes.
1 to 6.
6, post imposed.
Cost impose. Only one. What they will a total cost of 5,000 jointly and severally on respondent numbers 1 to 6. Not each one. You will pool your resources. You will pool your resources. Do some arithmetic and mathematics.
We have already sanctioned the amount. So now I don't have any control. Just
No, you see, amounts are sanctioned. There's no dearth of sanctioning. It's the question of will. You see, I would not have come in this belt had it not for this travel of this road. I'm not that ill that I will have to strap a belt and then be in the court. But it is because of that journey that I'm compelled to wear this belt as a security that I don't fall ill. And I'm not joking when I say, you may not be knowing, I have a slip disc of L3, L4 and L5. And the pressure which I have while traveling this road, you can't measure the amount of pain I have. And despite that, I try to be in a very good mood the entire day. I crack jokes, I laugh at myself. I even make some comments here and there, very light comments, just to make my mood lighter so that I forget my pain. That is the extent of this road. And you see, I am here as a guest. I'll be here for 2 weeks, maybe 4 weeks, not more. So I don't suffer because of that. Apart from this 2 weeks I am here. But what if I am suffering that much? What happens to a common man?
absolutely.
What happens to a common man? When you'll find litigations with regard to election petition, then you will find a new word coined out by the Supreme Court of India. They use the word little man. Only that word is used only in respect of election petitions, nowhere else. Word used, otherwise it is common man, R.K. Lakshman. And only in case of election petition, you will see the Supreme Court using the word little man. That will make you understand what the idea is.
Of last or 28/8/2024 and petitioner,
Make it on Monday.
my lord.
Make it
My-
on Monday.
Yes.
Lordship, may I beg to mention one unlisted motion, Lordship. This is with regard to a transfer petition.
Okay.
Unless.
That's it. I beg to mention item number 4 for I want to withdraw this matter as the petitioner don't want to press this matter anymore.
Want to withdraw the matter?
Yes.
Okay. Miss
T. Rimi.
T.
Rimi.
T. R.I.M.I. Rimi.
RIMI, yes.
T. Rimi, learned counsel for the petitioner, upon instructions. Please to allow her to withdraw the matter. Full stop. Mr. G. Tarak, learned standing counsel for the RWD is present. Full stop. The prayer is allowed. The matter is dismissed on withdrawal.
God bless you.
May I please, Lordship? Lordship, here in this case, I am appearing on behalf of the petitioner. Lordship, I would like to
Well, this is.
draw the attention of this Lordship regarding the malified intention of the respondent number 3, that despite the direction of this honorable court to remand back the matter to the Director DRDA and for approval of the tender to the petitioner, but they have violated the order and issued
Where is the order of the court?
Lordship.
Where is the previous order of the court? Which page?
Page number 30. This is the order passed by this honorable court on dated 24/5/2024. Lordship, the case of the petitioner is that
Just a moment, just a moment. Give me 2 minutes.
relevant page is last page, page 43.
Give me 2 minutes.
Lordship,
Give me 2 minutes. Let me
Lord.
read it. Yes, after this, what has happened?
Lordship, thereafter, we have supplied a copy of this order to the respondent, and the same has been acknowledged on 31/5/2024. But despite the clear direction by this honorable court to remand back the matter to the Director Rural Development Department to undertake an exercise of the for approval of the recommendation made by Project Director DRDA Kurungkume in respect of NIT dated 21/8/2023 for procurement of material pertaining to MG Naregas for CD block Polasang package number 8. The said exercise has to be done within 2 weeks. But despite of this order, Lordship, page number 44, annexure 9, in violation of this order passed by this honorable court, the respondent number 3 has again issued letter of intent to NK Enterprise, private respondent number 8. As such, I have filed this writ petition.
Okay.
Lordship.
Yes, you file your affidavit.
My lord, pleadings are exchanged, my lord. Now, my lord, in this case, my lord, in the motion also, my lord, since no notice was issued, my lord, that is because of the reason this case has been again listed for motion, my lord. It was in the order column also, my lord, this matter.
No, that's okay.
On the
But
first
what do you have to say?
Yes, my lord,
Affidavits have been exchanged.
exchange, my lord. They sought tried to file rejoinder, my lord, on the last occasion, my lord. But since no notice was issued, my lord, because of the reason this matter has been fixed or has been listed in motion column.
Okay. What is the stand of the respondents?
My lord, to be honest, my lord, I am not prepared today, my lord, because I was on the impression that only notice will be issued, my lord.
Oh, no, I have told you so many times in this bench.
No, sir.
Every time is a hearing day.
My lord.
Motion, admission, hearing, orders, every time I can
Can it be on Tuesday, my lord?
Lordship,
take up a hearing.
Lordship, it may be
Just
fixed
a
for
moment,
tomorrow,
Just
Lordship.
a moment. Just a moment. I'm not very happy when counsel, when he's making a submission, somebody else interrupts.
Lordship.
I'm not very happy. We were groomed up in an environment where my senior asked me to sit down when the other side is arguing. We would not stand up. That was during my time when I was a new entrant. Definitely somebody is arguing, you can't speak at that point of time. Unless, of course, you have a city bus to catch.
Lordship.
You have a city bus to catch. 11:30 is the city bus time. No other city bus will be here.
Lordship.
You are catching a city bus? No.
No.
You can
Yeah.
please have a patience. No, because I am told here 5 o'clock,
Yes,
there
Lord.
is a bus where it waits for no one.
Yes.
People want to catch that bus 5 o'clock.
Yes, sir.
So people are in a hurry at that time. That's why I'm asking you about city bus. Just a moment. Where is the previous High Court order? Which page you said?
Uh,
High Court order, earlier,
page number 30, 30,
30.
annexure 8.
My lord, the relevant portion would be para 16, my lord.
Just now.
Yes.
पुराना है।
No, but you see, the respondents have taken a stand that the SOP of 20 August 2021 was not produced. And as per that, the scrutiny of tender documents is to be made by the project director and sent for further scrutiny to the government for approval and acceptance. See, if that is the SOP, then the order of the High Court is incorrect to send the matter to the project director.
Lordship.
Then if the order is incorrect, it can't be enforced. This SOP was never before us on the,
Yes,
in the
sir.
earlier round of writ petition.
Lordship.
Then
Lordship.
can the court, by its order, create a circumstances which is not envisaged?
Lordship, the para 23, Lordship may kindly read the para 23.
Para 23 of?
The
No, I've
order-
seen that. You see, that in the earlier round of litigation, it was never pointed out that there is an SOP which prescribes a particular procedure. So we found fault with that and we sent the matter to the director.
Yes, Lordship.
Now, in their affidavit, in opposition, they say that there's a procedure prescribed which is not brought to the notice of the court, and therefore the order. And therefore, what the procedure, what they did is in accordance with law. They have produced the SOP along with the affidavit in opposition. Now,
Lordship.
how do you respond to that?
Lordship, there is a clear direction from this honorable court
No, you see,
for
Please.
appro-
please don't stay there only.
Lordship.
We have said something more. The High Court issued a direction to be sent to the director. But as per the SOP, director is not even a authorized person to appreciate. As per the SOP of 20 August, It is the project director and the government. The director, DRDA, is not a competent authority because when they say government, government would mean only the secretary. A director is not a government.
Lordship, with regards to a step taken by the respondent, I was not aware of anything.
No, now you are aware, after this affidavit, now you are aware. Please find fault with the steps taken. Can you find fault with the procedure adopted in light of the SOP while order dated 20 August 2021?
Lordship.
No, then sorry, we are dismissing it. It would not be maintainable. Challenge would not be maintainable. Heard. Mr.
Titaba,
Tinaba,
Titaba.
Titaba, learned
Yes.
counsel for the petitioners. Also, oh, I'm sorry. You wanted notice to be issued.
Yes, no. Well, maybe this is.
Why?
Yes.
Otherwise, you go home disappointed that I asked the court to issue a notice. Notice was not issued. You'll
No,
go
I
to
will
long
be very
face.
happy.
You'll be happy.
Yes, sir.
Lordship,
I don't
notice
know.
may be issued in that case.
You're worse than what you call?
It's a million.
In Hindi, I don't know the English term. I hope you can tell me what is it. We call it Hindi is called bin penda ka lota. That means a lota is something like a small water cubicle
Well,
which can fall at any side.
well.
So with pressure put one place, it goes to one side.
Well.
What is the in English equivalent, Mr. Tara? One which tilts with the weight. There should be something English equivalent. Huh? Okay.
Lordship,
Mr.
I will file rejoinder, Lordship. I'll file rejoinder.
Pardon me?
I will file my rejoinder.
No, rejoinder is not required. You see, the issue is that rejoinder will not change the law.
Because Lordship, step taken by the respondent authority is not known to me. And
No, you show us the fault. It's a legal argument. It's not a factual argument. It's a legal argument where you show us that how this procedure adopted is wrong. Merely because the High Court has issued an order that go to a particular officer. If that officer does not have the competence, can that be an enforceable order?
it may not.
No. So then we can't help it. Also have Mr. B. Pichalan, standing counsel for the Rural Development Department, as well as Mr.
G.
G.
G. Kaplan. Your Honor, I'm appearing on behalf of respondent number 8.
Spelling.
Respondent number 8.
Spelling.
Oh, G. Kaku. G. Kaku. G. K. Kaku. G. Kaku.
Learned counsel for the respondent number.
8. Respondent number 8.
And Ms. P. Pangul, and government advocate appearing for respondent numbers.
1.
1. Next, brother. This court in the earlier round of litigation, by the order dated 24/5/2024, passed in WPC 51/2024. Had examined the tender process being NIT/IOB, published on 21/8/2023 for supply and procurement of materials pertaining to MG Narega Works 2023-24 for capital CD block, Polosang, POLOSANG, under Kurum Kume district, under package number Roman 8, which was issued by the project director, District Rural Development Agency, Poloriang, KOLORIANG, Kurum Kume district. And after examining various tender clauses, including the issue of justifiable rates, formed an opinion that the act of the project director was an act of subordination in relation to clause 8 within bracket Roman 22 XX 23 XX of the 2024, passed by this court. In WPC 51 of 2024, issued a letter of intent dated 21/6/2024 in respect of the said tender in favor of the respondent number 8. Full stop. Next paragraph. Accordingly, the learned counsel for the petitioner has submitted that the action of the respondent number 3, i.e. the director, sorry, respondent number 2, i.e. the director, Rural Development Department, in issuing the letter of intent dated 21/6/2024 was illegal and mala fide exercise of power. Illegal and done in mala fide exercise of power. Moreover, it is submitted that this was a case of non-compliance of the order of this court. Next one. The learned counsel for the Rural Development Department has referred to the affidavit in opposition filed on behalf of respondent numbers 2 to 7, and it is submitted that in the earlier petition, this court was not apprised of SOP, standard operating procedure, within bracket SOP, for procurement of material under MG Narega by the Rural Development Department, Government of Arunachal Pradesh, by order number capital CD dash CE within bracket RE bracket closed 01/2007-808 dated 28/2021, which amongst others, provided under clause 6 of the SOP that inverted commas that after scrutiny entered documents, the project director shall send the tender documents of technical responsive firms to the government for further scrutiny and approval of the acceptance. Full stop. Under clause 8 thereof, after the inverted commas, after approval of the government, the joint director within RE bracket closed, with due approval from the director, RD, shall issue a letter of intent to the successful bidders. Full stop. The bidders shall submit acceptance letter to the joint director for acceptance. Full stop. Inverted comma closed. Full stop. Next paragraph. Next paragraph. It is. It is not in dispute that the tender board by proceedings dated 24/5/2024. Sorry, 5/1/2024. From a comparative statement. And the respondent number 8 was held to be L1 bidder. It is next paragraph. In this, in the affidavit in opposition filed by the numbers 2 to 7, it has been projected that before filing of WPC 51 of 2024, the respondent number 8 had executed part of the work and bill dated 3/2/2024 for a sum of rupees 20,21,800, bill dated 3/2/2024 for rupees 22,20,000, bill number, sorry, the bill dated 3/2/2024 for rupees 20,21,800, and the bill dated 3/2/2024 for rupees 20,20,800 had been raised, and that after issuance of the letter of intent dated 21/6/2024, the respondent number 8 has submitted bill dated 25/6/2024 for rupees 7,92,380, and bill dated 25/6/2024 for 2,20,480 after doing the work. And accordingly, the respondent number 8 has done public executed work amounting to rupees 72,76,460,
My calculation might be wrong.
This one is also next point is also also projected that the LOI dated 21/6/2024 was issued after the board decision taken in the proceedings dated 26/2024. Next paragraph. According to the police constraint to hold that in the present case, the respondent numbers 2 to 6 has been able to demonstrate that the earlier order dated 24/5/2024 passed by this court in WBC 51 of 2024 was passed without the SOP wide order dated 28/2021 being placed before this court. Next paragraph. The court is conscious of the fact that they not examining the matter in review of the judgment on order dated 24/5/2024 passed in WBC 51/2024. Nonetheless, having noted that as per the contention made by the respondent numbers 2 to 7, that prior to the first order in this petition being passed on 1/7/2024, a substantial portion of work has been completed by the respondent number 8. The court is inclined to hold that the mere fact that the LOI dated (21/6/2024) was issued without adhering to the directions contained in the order dated 24/5/2024 passed in WBC 51/2024. Nonetheless, the manner of proceedings cannot be held to be not in accordance with the standard operating procedure wide order dated 28/2021 issued by the Rural Development Department, Itanagar. So moreover, on part of the substantial part of the work being already executed by the respondent number 8, the court is disinclined to interfere in award of LOI dated 21/6/2024. Next, accordingly, the great petition stands dismissed. So the parties are bear their own cost.
Development.
My lord, as I pointed out last time, there is a calculation pattern a mistake in the patterns. Lordship may kindly come to page 13. page 13, my lord. My lord, this is the calculation,
Oh,
the
interest on rent.
compensation
Yes, I
amount.
remember.
Yes.
Interest on rent.
Yeah, 14 is the section
Okay.
80 has been,
Yes, you have instructions?
No, my lordship, we haven't received our instructions.
this mistake has to be rectified, my lord. Otherwise, it will
I
be,
understand, you are right. That's why we took notice of
Yes.
89. Same thing.
so, my lord, this may be disposed of
I think
direct.
we have been able to convey what was intended in the order dated 89.
Yes,
Yes,
Then what is the authority doing?
this matter was listed on Monday, my lordship. I'll take instruction.
You see, you have got a copy of the order,
Yes, my lordship.
89.
Yes, my
There are
lordship.
two components of this order. Number one, Mr. Patin says that rent is calculated till 2019. Now he is entitled to 2023. So you have to either say yes or no.
but in fact, in their affidavit, they have also
No,
said
that's
that,
okay.
yes.
That's
they-
okay, but now after this order, the authorities will only have to tick mark, yes or no.
Yes.
But in their
Okay.
affidavit, they have also
What is-
stated that.
What are those questions called? What are those questions called? You have to answer by yes or no.
Yes, my lordship.
What is that called? What is that called in examination?
Yes, my lordship.
Where you have to answer yes or no. In examination, what is the term used?
Optional.
Optional questions. So that is the only option. Either you say yes or no. Second is that he says that interest cannot be added on the rent. So he says that you deduct the rent. Deduct interest on rent. So he's wanting to make the government to profit. Now the government will also only have to say if they want profit, yes, or they don't want profit, no.
My lord, just in their affidavit.
No, not that. You see, the government may want to enrich you. You are fair enough to say that you don't want interest. But let us suppose the government wants to pay you interest. Will you say no?
On
Right.
Monday, my lordship. I'll
On
take
Monday,
instructions.
okay. Will you be able to contact them?
Yes, my lordship. We have communicated, my lordship.
Okay.
You
Mr. Patil,
kindly refer to your affidavit of your.
Yes.
Yes.
Mr. Patil, we give them one more chance.
My lord.
Not Monday, we take it up on
Wednesday?
Wednesday.
You have 2 or 3 days time, take your leisure time and then please do it.
Yes. Yes, 14.
1st of October.
Yes, my lordship.
It goes to 1st of October.
1st October.
Correct? You have 2 or 3 clear days time. Mr. T. Patil and counsel for the petitioners was referred to the order dated 18/9/2024, which wherein his submissions have been recorded. Next paragraph. Ms. T. Wangmu, Leonard. Sorry, Ms.
My lord, in my observation, has also referred to paragraph 7 of the affidavit filed by the respondent.
Okay, so he also submits that his statement is in accordance with the stand taken in
Paragraph 7
paragraph 7
of the opposition, affidavit in opposition filed by the
of the
deputy commissioner.
affidavit in opposition filed by the respondent number
Respondent number
6.
6.
6.
Okay. The Learned Government Advocate submits that she has communicated with the authorities and has not received a response. She prays that the matter be listed on 1/10/2024, by which time she will obtain instructions. First of Mr.
On behalf of the chapter,
Please tell the spelling again, I forgot. Please tell the name again. Learned Counsel for Respondent. Learned Counsel appearing on behalf of Mr. M. Kato, Learned DSGI, and Mr.
Appearing for on behalf of Mr. D. Kandu.
Your name?
Beeper.
Please write it there. Learned Counsel appearing on behalf of Mr. D. Kamdal, Standing Counsel for the Land Management Department. Full stop. Next para. Next para. The learned government advocate. The respondent authorities shall cooperate shall cooperate with the learned government advocate and provide her with the instructions timely so as to address the court next date of listing. Next para list on 1/10/2024.
When? Next date.
1/10/2024. Yes.
Madam, I have received instruction to file by Monday. I'll file my affidavit in opposition.
Okay. By Monday.
Yes.
My lord, difficulty here is the, my lord, there is no such as stay interim order, only is the subject to the outcome. my lord. So what is the apprehension is, my lord, tomorrow, if there is a more delay, my lord, then,
Okay, we are fixing on first. We're not.
my
doing a
lord, this
long
should be
day.
the, this
Okay.
thing, my lord.
No, because otherwise, Mr. Tarak has never disappointed us. When he says he will do it tomorrow, then means
Yes, yes, yes.
he means it.
Yes.
There are several other writ petition
No, that's
against.
okay. But we know that you not. Mr. R. Sonar, counsel for the petitioner, is present. Mr. G. Tarak Lanet, standing counsel for the RWC, submits that he has received instructions and will be filing affidavit in opposition by 9/2024. List on 1/10/2024.
Oh, yes.
Deeply ordered.
Mr. Tapu, we have not seen him for this week. His
My lord, I was just sitting, my lord, only here.
Huh? I did not notice him.
My
Okay.
lord.
Your Honor, this is a contempt case for willfully and deliberately disobeying this honorable court's order. Your Honor, a prima facie case of contempt is being established here, Your Honor. If I may, Your Honor.
Just a moment. Who's appealing for 1 and 2? Yes. Yes. What do you say?
I'm for the both the respondent.
Yes. What do you say? Tell us something.
I beg to submit that I have just yesterday filed wakalatnama and I am yet to receive the copy of the petition.
In the contempt notice was issued, your client must have received it. Otherwise, how will you know that there is a contempt?
Yes, we have received.
Along with the contempt, notice was not issued by the registry.
Notice has been issued by the.
No, but notice without copy of petition is unbelievable.
We have sent a copy of the notice.
Okay, give it to your friend, one more copy.
No, we have already given them copies of the petition. We have already given them copies of the.
Your Honor, I'll have instruction from my client.
No, you have given him today.
No, we have already given copies of the petition to them.
Please don't complicate things. He said that he has not received a copy. Give him a photocopy of the contempt petition. Correct. Correct, but don't make those statements. Because then things will go in a different turn. Because not only contempt, but the respondents is denying receipt of process issued. It's very, very easy for us to see that. You see, because a postal receipt will have the weight. So it's not that the registry will send something else. Correct? So be cautious. Your clients will lead you to a very difficult situation. Don't always believe. Don't always believe them. How will he come to know about the contempt without receiving a notice? If he has received a notice, it's not possible that he'll receive a notice without copy of the petition. Don't put yourself to a bad situation. Please give him a copy. Okay.
Your Honor, a prima facie case of contempt is be established, Your
Okay,
Honor.
can't do anything. What will you do?
Your Honor,
Because
the thing is, my salary has for last 3 months I have not received, and I have 2 minor children to take care of, and I'm the sole earner in my family, Your Honor. So that has to be kindly taken into consideration, Your Honor.
okay. Okay.
And legal notice was served on 23rd August. Your Honor, if you look at it, if you look at the letter was
These
forwarded.
things are necessary. Well, we can't do everything. We can't be too touchy. It is not in heard Mr.
Mukbang Patel.
M. Patin,
Yes, sir.
Learned Counsel for the petitioner. Mr.
A Gamre, on behalf of B Jamo.
No, your name, your name.
A Gamre,
A.
Gamre,
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 Spelling?
Gamre.
Gamre, Gamre. Learned Counsel appears for the respondent numbers 1 and prays for a copy of the contempt petition. Stop. Though the court also gives the view that along with the notice, the respondents must have received a copy of the contempt petition, nonetheless, the learned counsel for the petitioner shall provide one copy of the contempt petition to the learned counsel for the respondent numbers 1 and 2 in course of the day. Next para. The learned counsel for the petitioner has submitted that the petitioner has not received his salary for last 3 months. And he has a family with 2 minor children and is facing starvation. Next para. Where is the order of the court?
Order of the court is page number, annexation number 1, page number 20. You know, the last paragraph is the relevant portion.
You get the records of this WPC 339 of 2024. Record of this case. Yeah. WPC 339 2024. Yeah, yeah, no? Wait for some time. 339 of 2024. Okay. Is that? So accordingly, the pendency of the contempt petition shall not be a bar for the respondents to reduce the current salary of the petitioner. Most of the Learned Counsel for the respondents shall transmit a downloaded copy of this order, respondent numbers 1 and 2, to bring this order to the notice. Okay, let's go. Let's continue. List,
Your Honor,
list
next date,
after, and see, give a fixed date after vacation,
Your Honor,
November first week.
kindly, 1 week, Your Honor, kindly 1 week, after a week, Your Honor,
Pardon me,
kindly after a week, Your Honor.
after week is very close to Puja, we can't afford to have that.
Because, there's a prima facie case of
No,
contempt.
we have directed them to issue, to make you the current salary payment. The direction is already given. First week, November. November first week.
Highly
We are
object.
giving you time for the payment of salary is made. Ask your clients to make payment of salary. Hmm? 3010, okay, 30/10/2024.
Highly object.
Lordship, on last occasion lawsuit, there was a query from the Sonora Court lawsuit, the capacity of the deputy commissioner to make internal arrangement among the staffs and the transfer of the staffs in the district lawsuit.
Yes, yes. I
As
know.
per this lawsuit, the deputy commissioner belongs to the district cater lawsuit. And deputy commissioner is the appointing authority and he is the lawsuit transferring authority.
Oh, he's the appointing authority.
Yes, yes.
Okay. Okay.
Apart from that, this is only the internal arrangement lawsuit
I understand.
within the very same place lawsuit.
Then it can't be helped. We cannot interfere with the order of transfer.
Your lordship, I have something to submit, your lordship.
Yes.
Your lordship, may I bring you to page 25, your lordship?
20?
25, your lordship.
25.
Yes, your lordship. 25 of the writ petition, your lordship.
Yes.
This is my representation, your lordship, where I pray before the respondent to, that is deputy commissioner, and I informed him about my bad health. And since I'm at the fag end of my retirement, so at least place me at such duty where lighter work is involved. So based on this, I also enclosed at page 26, 27, my medical report was also enclosed. On the basis of this representation, your lordship, my transfer was issued. So my transfer was the transfer on request, your lordship. Although your lordship, at the top it is written 19th July, but at the middle part it is issued on 22nd July. That is page 28, your lordship. Your lordship, now impugned order is at lordship. It is at page 35. That is the cancellation. Page 35, your lordship.
That is 7.
Page 35, your lordship. Now, this is the cancellation order, and purportedly, your lordship, it appears that this cancellation has been issued on the very next day of the issuance of my transfer order, and without even assigning the reason, your lordship. My stand is that, your lordship, because this honorable court in Katana petitions has held that transfer or modification or cancellation of transfer order must be supported with some reason, your lordship. But my cancellation has been issued, your lordship, without even assigning the reason, your lordship. Because that too, particularly when my cancellation is being cancelled on the very next day of its issuance, your lordship, I ought to have been aware about the reason why my cancellation is being issued, your lordship. And before that, your lordship, when my transfer order was issued, which is at page 28. I have even been released. And my release order is at page 29, Your Lordship. Page 29 is my release order, Your Lordship. And thereafter, on the next page, Your Lordship, that is my joining report was there. When I went to join in the office where I have been transferred, Your Lordship, page 31, this is what the respondent number 3 has done with me, Your Lordship. My joining report has not been accepted. And on the basis of this intimation by the respondent number 3 to the respondent number 2, my cancellation of transfer was done, Your Lordship. Hence, Your Lordship, my humble submission.
What is the decision you are relying on? That for transfer, recalling the order, there has to be a speaking order.
Yes, Your Lordship.
Which judgment you are relying on?
Your Lordship, I am relying on the judgment. 3 judgments are there. First, Supreme Court judgment 2022 14 SCC 187.
2022
14 SCC 187, Your Lordship.
Name of the parties?
The name of the petitioner is withheld, Miss X versus Registrar General High Court of Madhya Pradesh and another.
Yes.
Your Lordship, the law which has been laid down here is at para 61 and para 64. There, Your Lordship, while holding the transfer order when it can be melified, the Honorable Supreme Court has held that melice are of two kinds. One is melice in law and another is melice in fact. Para 61, and I quote, Your Lordship, it is tried that the state is under the obligation to act fairly.
Yes, pass it on. Pass it on.
Your Lordship, just.
The other citation?
This is a page 61, Your Lordship. Oh, para 61, sorry. May I read, Your Lordship?
Any other citation?
Another citation of the division of bench of this Honorable Court, Your Lordship. This is 2023 5 GLT 281, Your Lordship.
5 GLT page?
Page 280.
Name of the parties?
Nyamo Rina versus State of Arunachal Pradesh.
Paragraph?
Paragraph, Your Lordship, para 29 and para 30, Your Lordship. The division bench. Yes, Your Lordship. This was also in respect of cancellation, Your Lordship.
Yes, you are filing an affidavit? No, for the health department? And and the deputy commissioner also filing an affidavit?
Lordship, our affidavit is ready, Lordship.
Okay, how much time?
Within a week, Lordship. A week, Lordship.
Within a week. Okay.
Lordship, may I?
Your lordship, another judgment was also there. Your
No, since they are filing an affidavit, we not prepare right now.
Lordship, if Lordship see, there's a judgment of this Honorable Court, Lordship. When the transfer is within the Lordship, same Lordship, premises.
I understand, but we'll have to adjudicate. You must put this stand so that we can take note of that. All sides are represented. Next, Mr. S. Tapin, a senior government advocate, has referred to the order dated 19/9/2024, and he has submitted that in connection with the appointment of ministerial staff, the deputy commissioner is the appointing authority, and therefore he also has the power to transfer ministerial staff. First off, he submits that he has received instructions and would be filing an affidavit in opposition within a week. First off, Mr. T. Tagum, the next standing counsel for the Health Department, also prays for granted time to file affidavit in opposition in the matter. Next para, list on when?
On third, Lordship. On third of.
It is very close to vacation. Okay,
Your
3/10/2024. Okay.
Your lordship,
Just say that the short adjournment has been granted. The prayer in the introductory application shall also be considered on 3/10/2024. Your citations. Yes. Yes.
May I please ask? In the application,
Here is the Deputy Commissioner's
Interlocutory
order of
application.
23/7/2024.
yes,
Deputy Commissioner's order of 23/7/2024. Where is that?
yes.
Where is that order?
It is in the main petition lot.
Yes, which page?
Main petition.
In 39, Lordship. 39.
39.
Lost.
Yes. 37 to 45. So, my lord,
Just a moment.
here I am being actually aggrieved by this.
Just a moment. Just a moment. We'll come back to you. Just a moment. Yes, now tell us, what do you want?
My lord, here I am being aggrieved by this imping order, eviction order. I filed by way of writ petition number 292 AP of 2024, whereby this honorable court has granted interim order dated 26/7/2024. Then this interim order was granted on establishing the prima facie case, and thereby the respondent, they have now filed a IA 166 for vacation of interim order in this interim order. So thereby my submission is that as your lordship has already observed on 16/9/2024, whereby by invoking Article 226 Clause 3 of the Constitution of India, wherein interim order will be terminated by automatically vacated as and when an application is filed. So here my grievances is that since the matter is fixed on 23rd October for hearing, and on top of that, state respondent number 2 only has filed affidavit in opposition, and the respondent, they have yet to file their affidavit, and more specifically respondent number 4, his affidavit is very important to adjudicate this instant case. Therefore, my submission is that since if it interim order granted by this honorable court on 26/7/24 is not extended, my entire writ petition become infructuous. Therefore, my submission is that
we can't help it. You see, 226(3) operates, and that operates without any intervention of the court. That's number one. Second is that we committed a mistake in the next order to extend the interim order further, which could not have been done. After the effect of the interim order being vacated, without a reasoned order, the interim order which was extended was an inadvertent mistake. You see, please show us from any law or any court interpretation.
Yes, Lordship.
To overcome order 226, the bar of order 226(3), our full bench has.
Yes, Lordship.
Now this, you see, the full bench has clarified how this 226(3) will operate, and it will operate without an intervention of the court. An interlocutory application is filed for vacating ex parte order, and if it is not disposed of within 15 days, then it automatically gets vacated. You don't need a judicial order at all. Therefore, it can't be extended. 226(3) cannot be frustrated. A constitutional provision cannot be frustrated. You see, when I started my career lawyer, then we had only one duty when it comes to this 226(3) application, that you be vigilant, get the matter listed before the court, before even if I am a lawyer for the petition, for the writ petitioner, it was my duty to see that the interim application of 226(3) gets listed before the court before expiry of 220 these 15 days.
No, sir.
Correct.
Correct.
Now, in this case, 226(3), so it automatically vacates. How can I revise that order which is already lapsed?
So, Lordship, my only submission is that since this is the case, this 226 clause 3 will only attract and applicable in a situation where the interim order has been heard ex parte without furnishing a copy and the relevant record to the other side of our respondent. But here in this instant case, I've already submitted, furnished the copy, and the learned counsel of the respondents, they, on behalf of all the respondents, they have acknowledged the notice and they have heard, and the matter is heard. Therefore, in this instant case, I have a citation. So, take your lordship at page 16, para 26 is the operative portion. May I read the operative? Para 26. In this case, it is unnecessary for this court to decide whether clause 3 of Article 226 of the Constitution of India is mandatory or directory. Clause
Paragraph you are reading.
Clause 3
Paragraph?
of Article
Which
paragraph
paragraph?
26, Lord.
86.
Page 16, down below is the page number.
86.
Yes. Yes. Page 26. Para 26. Merit. In this case, it is unnecessary for this court to decide whether clause 3 of Article 226 of the Constitution of India is mandatory or directory. Clause 3 of Article 226 read as, down below, clause 3, where any party against whom an interim order, way of injunction or stay or in any other manner is made on or in any proceeding relating to a petition under clause 1 without a furnishing such party copies of such petition and all document in support of the plea of such intention or interim order, and clause B, giving such party an opportunity of being heard, makes an application to the Honorable Court for vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made, or the counsel of such party, the High Court shall dispose the application within a period of 2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on the last day of year, before expiry of the next day afterwards on which the High Court is open. And if the application is not so disposed of, the interim order shall, on the expiry of that period, or as the case may be, the expiry of the said next day, stand vacated. So, on its plain reading, clause 3 is applicable only when an interim relief is granted without furnishing a copy of the writ petition along with supporting document of the opposite party and without hearing the opposite party, Lordship. This to be noted. Even assuming that clause 3 is not directory, it provides for an automatic vacation of interim relief only if the aggrieved party makes an application for vacating the interim relief. And when the application for vacating stay is not heard within time specified. Clause 3 will not apply when an interim order in the writ petition under Article 226 is passed after receipt of the copy of the writ petition on all concerned parties and after giving them an opportunity of being heard. It applies only to ex parte ad interim order, Lordship. So therefore, my submission is that since the copy has been furnished to the respondents, since they have been heard, opportunity has been given to them. Therefore, the IA which they have filed for vacation, IA 66 which the respondent has filed for vacation of the interim order is not tenable if interim order is vacated, entire my writ petition, it become infructuous, and otherwise also the date has been fixed, in a shorter date has been fixed on 23rd October. Therefore, my prayer is that my interim order dated 26/7/2007, 24.
Petitioner has already filed their objections in the IA also, in my IA also. Otherwise, here lawsuit, if lawsuit takes up my lawsuit IA, in the last page 49 lawsuit. This is, urgency is there in this case lawsuit. The district hospital building already completed in December 2023 lawsuit. Because of this approach road only lawsuit, the inter-building lawsuit is not being operated lawsuit. And the people of the inter-district is suffering lawsuit. Page 49 lawsuit. Building is completed lawsuit. Lawsuit will find encroachment. This is the lawsuit, the house lawsuit constructed by the petitioner, which is obstructing the lawsuit, the proposed approach road lawsuit. And the petitioner is not the normal person lawsuit. It's not the case lawsuit, he is a poor person. He contested the last election lawsuit. He is a very known person in the lawsuit area. Even then lawsuit, his conduct lawsuit. And it's admitted position that lawsuit, this is a government lawsuit. It's not disputed lawsuit. And because of this approach road only lawsuit, the building is not lawsuit, road on lawsuit, operation lawsuit. And people are suffering lawsuit. And it could not be handed over to the lawsuit health department lawsuit. Since December lawsuit, the matter is just pending like that lawsuit. And the old building lawsuit can see the photographs lawsuit. The waters are lawsuit oozing out from the lawsuit ceiling lawsuit. On merit, due process has been completed lawsuit. In earlier past round of litigation lawsuit, we remanded back the matter to the deputy commissioner to hear the petitioner and to pass an appropriate order in the appeal lawsuit. Accordingly, he was heard lawsuit, and region order has been passed lawsuit. And if lawsuit see the interim order passed by the Sonora Court lawsuit, if lawsuit see the interim order passed by the Sonora Court that in the day one lawsuit, basically there's no any region has been assigned requiring the passing of the interim order lawsuit. Therefore, also we came with these applications for vacations of the interim order in the interest of public safety. The balance of convenience lawsuit. In one hand, lawsuit, people of the inter-district suffering lawsuit in want of proper medical facilities lawsuit. This district hospital lawsuit of a district lawsuit. In other hand, lawsuit, the individual interest of the petitioner. So therefore, it may be heard on merit lawsuit, and in the matter can be lawsuit in the interest of justice lawsuit.
Okay, let the board be over. After that, I take up the hearing.
No.
We take up the hearing today.
No.
After the board is over, we'll take up the hearing. At the end of the board, we'll take up hearing of this matter.
Yeah, Lordship. Lordship, may please to pass over for timing, Lordship. This matter at 10. Just, Lordship, we engage, Lordship.
We engage means
Yes, another council.
without power, my lord.
Lordship, we filed the calendar, Lordship. Only file, Lordship. Just pass over for timing, Lordship. At 2, Lordship.
File here, application
education variation of the order. There is a transfer order which has been issued by the government, and accordingly he was transferred because there was a query which was made by this court that I am in charge assistant engineer. Now there is one judgment whether it should be replaced by a regular executive engineer or you are drawing a salary or in the rank of executive engineer. I have filed an application showing I am drawing the salary in the rank of executive engineer. So that's the ground where lordship
take
is.
it
Yes,
off
let him.
sometime.
let him-
Add to lordship.
Yeah.
Yes. Mr. Das, I will not be taking up a hearing today.
I'm sorry.
I will not be taking up hearing today
Oh, acha, acha.
because I have to, okay, you are also there.
Yes. Jadov is here.
Because this is going to take some time.
Hey, it'll take some time. Yes.
Because
Yes.
I have some urgent matter when I have to go to Delhi
Oh, Delhi.
tomorrow
Let come up.
for some official meeting.
But this will take some time, man.
Because
That's
if I will do it,
So your lordship is
since
going
I'll be
today.
traveling, I will not be in the bench.
Today your lordship is
Today night I will be traveling.
night.
Tomorrow morning I have to reach, tomorrow evening I have to reach Delhi.
One date may be fixed, man.
Let it come after vacation then.
After vacation only and now it's not possible.
Choose a date.
So,
Choose a date, Mr. Yadav.
maybe.
Dole, Mr. Dole.
Yes, as per your convenience. Maybe in the month of November. As per your convenience.
7th. 7th only Monday or sorry, October.
No, 7, somewhere in 21, 22, the second.
November 10th is 10th is Monday. 10th Sunday. 11th. 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 Huh? 11 is Monday. Right? Monday is good. Monday. No, Monday was only we can't say predict because this I only request, humbly request. It's difficult to write down, but it may be taken over for 2 days continuously in this case because I need some time to argue this matter because
I'll make mention in the order.
yes, that will be
You
better.
renew the prayer.
So how much time will you take?
So that I can't wait the whole day.
I can fix my time. I can finish it in 45 minutes. So
I can predict within 45
No,
minutes.
it's okay. I just observed in the order. that,
Yes, yes.
Mr. Das says that it may be spilled over to another day.
Yes.
So just make a mention and
let us fix the date first then.
October દિવસ સુધીમાં પહોંચી જાવ. October to May. 29, 30 years.
November 11, 12, okay. 11th and 12th of November.
11th is a Monday.
Monday, okay. 11th and 12th November.
Why 2 days?
No, Diganta suggested. I'll take 45 minutes.
Which my Yadav also said, 12th is a hearing day, is a Tuesday. So. বন্ধ হয়ে গেল সব।
Mr. D. Das, London Senior Counsel, assisted by Mr. S.R. Rahman and counsel for the petitioner, submits that he would require more than a day's time to make his submissions Withdrawal. Mr. Y. Duloy, Leonard. Counsel for respondent number
2 to 5.
2 to 5 submits that he would also take about an hour to make his submissions. Withdrawal. Accordingly, the court is inclined to fix another date for hearing of the matter. As the hearing will not be concluded in course of the day today, and the which will not be available from and this bench will not be available on 27/9/2024. Right. Next para. Mr. R.S. Nabam, the additional advocate general, along with his instructing counsel, and Mr. D. Kamduk, the counsel for the land management department, are present. Next para is agreed to by both sides. List the matter on 11/11
November.
2024.
Observation.
Please tell the inform the court in the mention hour so that the court is aware.
Mention can be made.
On the next date?
Yes, it can be spill over for an exit also.
That's why I've made a
Yes.
note in your order. What is this affidavit here for? I did not, it's writ petition 480. There's a additional affidavit 1 to 4. Keep it. somewhere. ये देखिए उसमें है कि नहीं affidavit. The additional advocate general yesterday in matter, I don't know, this is a file I did not read, and therefore I'm not aware of the facts, what is there. Yesterday in connection with an order, in connection with a matter, I have made an observation. You see, for quite a long time, when I'm finding litigations in this court with regard to land acquisitions, I find that there are many people who are coming up in the court claiming their right to a particular land which is being acquired. And therefore, it's like a phoenix. Somebody comes up from the ashes and then say that I am here, I am there, I am there. And then there are many litigations in the court, which are essentially civil. It's a civil litigation, purely civil litigation. Who is the owner of land X or who is the owner of land Y? Whether he's A, B, or C cannot be determined in a writ petition. That's one. Second is that we have made an observation that we have this Land Records Act 2000. It requires that the state will have land revenue staff. They will be required to maintain land records, including mutation records. So if I put up a question to be answered by the Chief Secretary and the Secretary Land Management Department, I've asked the government advocate to give a copy to Mr. Kamduk. So that if there is an authority, whether it is working, whether the state wants to implement the Land Records Act, so that there is clarity whenever any development work is coming up in the state, somebody or the other comes up and says, this is my land. If it is not his land, then he will say it is my community land. If it is not the community land, he will say that otherwise he has an interest because his forefathers were living here. So these are the litigations we are now facing.
You got it very correct, Margaret. It's not like unlike Assam, where they have a patta land something.
No, but here if you have an act which envisages mutation.
Even my lord, the lease agreement is for 35 years.
that is also not a rightful ownership. So for LPC is concerned, it's a temporary position matter. If you look, you
No,
also
that's fine.
rightly observe, my lord, you will also find in especially land compensation. One of the reason why they claim that this is my access to property, this is my
Yes,
property
yes.
property, with the use of evidence, my lord, the ownership.
And I have also recorded under which law a Gambura or a village headman maintains a truthful record of the land ownership. So it's not a record, it's a truthful record. Because he will say that in my memory, yes, XYZ was there. And I have such a weak memory that every day I have to ask the lawyers who are appearing before me daily that what is your name, because I forget. I can't remember a simple name. And for a Gambura to remember people who have left the village for 70, 80 years ago, he will say that he has know him. He's a man of my village. That's why we have posed a question. And perhaps I had forgot to mention that the notice should be sent to the Advocate General. So please see that either you or the Advocate General has the notice of that order. It is passed in which case? Motion matter. I will give you the number. At 2 o'clock, I'll find it and give you the number.
I have done I am doing some lot of land acquisition matter here itself. That also I try to find out in certain acts, whatever these acts are there. This is a problem so far as the very difficult.
You see the anxiety. Let us say that since Mr. Yadav is there, he's normally for central government organization.
Right.
Now, a project is envisaged that it will have a cost component of 1 rupee. Now, 100 people come up and say that we want a share of compensation. And then all of very funny things are coming up. In one of the litigations, we saw that after 20 years, somebody is claiming that we had fruit trees there. Now, after 20 years, this fruit tree will have lost its natural life. And you want a compensation now for oranges. I have also made a mention that even this time, I am carrying some Arunachal almonds. Not sorry, it's walnuts. It's a good one. I take it. Here I am purchasing it at yesterday. It was 900 rupees. In Guwahati, I get the same for 450 rupees a kg. I am purchasing at twice the price. Well, I am ordering compensation of crores of rupees on the ground of existence of cardamom and cardamom here, local cardamom. And this local those fruits and vegetables for which compensation are being asked is not available in the at least in Hardovan market. So I have serious doubts of hundreds of people coming up and claiming there to be land. If so much of cardamom trees, nuts trees are there, this would be a country which richer than California.
But
people will not even need compensation.
But 2-3 things are very important. I have seen in land acquisition matters. One is that they have rehabilitation, resettlement. This is I have seen in my case also, where a double enrichment under the Lara Act also, you get it, or under rehabilitation resettlement, whether you are entitled to get it or not. Because there is a policy.
And the difficult part is in some of the affidavits, I am finding that the state is rather supporting when it comes to the text of the affidavit. In many cases, I found that there are text in the statement in the affidavit in opposition, which actually favors issuance of land compensation. Very fantastic things are coming up.
But when, my lord, I have seen also, my lord, this estimate, all is prepared. All the authorities are there to prepare the estimate. At that relevant time, it's too late, a day, after 4 years and comes up before the can say we have some objection. That I have seen, my lord, lot of cases. Award has been passed long back and they come to the court and we said we have some objection. How it can be calculated, in what manner it has been calculated, how it has been acquired.
No, that's why you see.
So these are to be.
That's why you see, I also penned down an order. The theory is, you see, nobody is bringing on record the original DPR of the project. Nobody is bringing that. From the original DPR, we know that this is the project, extent of project. This is the land which is being required. And therefore, there's no use for a subsequent court directed, what do you call this, status reports or a verification report. Why should the court enter into that for the first place? So there's something wrong somewhere in the government department. Every land acquisition act says that the land would be acquired. All the preliminaries will be done before that. You pay compensation and then take over land. Here, very easily the land is being handed over to the government. Once possession is taken over, then comes all these litigations, all these questions of fact before the trial, before the High Court, alleging that compensation not been duly done. You send it for verification. So why is the court, the state government not notifying? We have complied with the requirements of land acquisition prior to the final notification. There's a lot of lapse, and when we see the amount of compensation being claimed, I ultimately think that it's taxpayers' money. I pay the tax.
Yes. Even assessment during assessment procedure also, 3 persons are there. The user agency, the district administration, then the land owners.
So why does the government does not take a policy decision? It's not taking a policy decision.
So they have taken, there is a cabinet decision has been taken. A policy has been taken by the government. In what manner, why they should be compensated in what manner? Apart from Larai, there is a policy which is made in pursuance to the policy by the government of India. And this has given to the state. Here also in state has taken the policy. Why? They should be, because once you take away the land, that right has been taken away because it's a state, my lord, where.
No, I don't say that don't pay compensation. What is the court query is that why these things are not settled? Who is the beneficiary? Why it is not settled before the land acquisition, land is actually taken over? Because in every litigation, it's not before parting of possession. It is after parting of possession that hundreds of people come up. That's why I'm using the word phoenix.
Yes.
There is another aspect.
But there is,
my lord, here, 1 kilometer population is in only 70. So here people are having access land. So that is why they are sometimes trying to force the central government to take the land with compensation.
Trying to force central government.
Like some cases, my lord, I have seen that they will take our land, this was occupied, this kind of things are also happening.
that's an absurd. I think I don't agree. Union of India makes a demand. I have seen a lot of cases. They makes a demand.
No,
and
maybe
it's a state land.
when Mr. Yadav is saying he must have some reason to say that.
Yes.
He must have some reason.
And the population is 70% only in 1 square kilometer. So they are having so much of access land.
They initially, what I am not saying in my case, they initially makes a demand. Thereafter, they will turn around and they say, no, we don't want. This is what is happening. Lot of cases.
Not in this case because I have not read this.
Not in this case.
But
We are not talking about this case. General, I am.
But in general, I am pained with the amount of compensation being demanded by persons who don't have a on document, they don't have a right.
No, that will be, my lord, this is very difficult. I tried to, whenever I am looking into the matters, first I said, where is a document? There, your lordship will find it difficult to get a document here. Community land, there are
That's
claims.
why I'm posing that question to
Yes,
the
I'd like to make
General.
one comment on the basis of the local newspaper of the Arunachal. Actually, what happened, my lord, there are some power of the attorney holders. They're moving around. There are some power attorney holders of the land. They are doing all court cases. So, lordship, that in any cases, my lord, the money should go to the exact beneficiaries, not to the power of attorney holder. That is.
Let me also add, if my friend says, my lord, now, my lord, I'm sorry to say, my lord, many uniform, my lord, they should not allow to play a chess game, my lord. That should be answered.
And it is under the act where the power of attorney can come to the court.
No, we are not disputing that,
Yes.
that fact.
And where is, I'm sorry to say, it never goes to the pocket of the power of attorney holder. It will only go to that landowner.
Yes.
Never it goes to a power of. My lord, let us make it very frankly, there may be some understanding between the power of attorney holder and landowners. Ultimately, the state is not so full to give this amount to the power of attorney holder. It will go to the landowners. Now, there is an understanding between landowners and power. That's a different thing. That's no, that is always happening.
That we should not. enter
That is
into.
always
That is-
happening, my lord.
That is,
Never it goes to power of attorney holder.
okay. But sorry, I couldn't take up the matter.
No, it's okay.
Because I have two matters where I have to pass orders.
Yes.
And then another matter I'm taking up. So today will not.
Only if your lordship takes up the transfer matter.
Fast.
Fix the passport matter.
That's
That's
fine.
no problem.
That's
Because
okay.
that matter will take.
That's fine. Supplementary था ना? Supplementary. हाँ भाई. ये वो कॉल कर दिया.
Oh, my lord. My lord, sometime. Here is my lord outside of the court. Sometime maybe.
Then we'll start some other matter. Okay, next matter. Yes.
May I please? So my only limited prayer is that today, actually, I am not ready for the main.
No, you see, because
Main-
that's why
Let the matter be.
no, there's again a public interest involved.
Lordship, since the Learned Council, he has submitted that I have encroached the land in question and it is a matter of public interest. That is fine. But my land is different from the land of respondent number 4, who is the medical department. And there is no any whispering of any complaint as such for any encroachment. And I have never encroached the approach route of the respondent. There is a clear road. I have not, neither I have encroached the right of way, nor I have violated any easementary right of the respondent. There is a approach road. Why an approach road is there? So intentionally, as my learned friend has admittedly submitted that, since my this petitioner is he is a politician.
Where is your land possession certificate?
No, Lordship, I have only applied for the land in question for regularization, and it is under active consideration.
Okay. But
so therefore,
you have purchased the land from someone. This land where you are staying, is it purchased from someone? This land you are occupying, whether it was purchased from someone?
No.
No. Then what is the source of your taking over possession of this said land?
The land here in the is occupied by me way back in 2009, and since 14 years.
You have occupied the land. This was a land of whose land was it? When you occupied, it was whose land?
Basically, the Lordship, it is the government and only within the notified area only. But the normal procedure, as far application formats, there is an indication date of occupation, date of application in the format itself.
No.
Then unless we occupy the land, government land, how we apply the land? That is the question. So date of occupation we have to indicate in the application format.
Okay.
Unless we occupy, we cannot apply.
You have occupied in 2019. 2009.
Yes, way back in 2009.
2009.
Yes.
Now, what is the document first in point of time when you assert your possessory right?
Yes, I am possessive.
When did you assert your possessive right over the land?
Since 2009.
Show us the document. Show us the document by which you have asserted your possessory right over the land adverse to the interest of the state.
So there is a document in the main petition.
Yes.
Of my main petition. It's Annexure 1, page 22.
This is a photograph.
Yes, this is the structure which I have constructed. And prior to this structure also, I have constructed a kacha house here.
No. Construction of a house is something different from any assertion of right for adverse possession. Where is that?
No, Lordship, here since I am to inform this honorable court is that since I am a politician, I am a politician by opposition, since I have been targeted, singled out, because in the entire vicinity of the Sanglang district, that way the land is allotted, that way the entire public, they are getting land allotment. I have not even an inch of land has been allotted in my name or in my family's name. So I also have the right to have the allotment from the government. I have right to live. I have right to obtain the land allotment from the government. When everybody is getting, why I have been targeted and singled out.
Fundamental right.
There is a vested interest, there is a bias. And here in this instant case, the impugned order has been passed since the respondent number 2, who is happened to be a deputy commissioner as well as appellate court. And in this instant case, he himself is the respondent herein, who is interested party. And he is deciding the case, he himself. Then how we could expect any justice? There cannot happen.
No, unfortunately, you are a politician. You could have moved through someone in the legislative assembly.
Lord, sir, I am badly targeted, singled out.
That's why, as a politician, you should have moved the legislative assembly to say that if it is a government land, the deputy commissioner should not adjudicate. It should be adjudicated by X, Y, Z. You give the names. You appoint arbitrators. That in a government land, Eviction of Unauthorized Occupants Act 1971 by the central government as well as adopted by the state government. You challenge that act. Every land where the government is a party, the eviction is taken up by the deputy commissioner all throughout the country. What is so wrong about it? Entire land in a district is vested of the government is vested in the deputy commissioner.
My lord, here, as per the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act, the law is there, but this law itself negates the interest of the public. Why I am saying so is that because whenever we are going to
no, we are not hearing a public interest litigation. What affects the interest of the public, let someone else decide. Please tell us about your right. I am asking you a question. Where is a documentary evidence that you have asserted your adverse possessory right against the government? You are showing us the photograph. Photograph does not help us. Photograph is not a documentary evidence of assertion of adverse title.
Lordship, I have to the effect, I have also submitted the repeated application, even application format which I sought for regularization of my occupied land have been denied to me. I have been denied even the application format. Form,
Application form,
application form. I have been denied.
you don't get it.
Yes,
You have to.
because they do not, because forcefully I
No,
cannot
no,
obtain.
it's something news to me. To apply in a format, you have to request the government to give you a copy of application form. Only on that application form you are supposed to fill up. You can't type it in a plain paper and give it to the government. I did not follow you. I did not understand. You are trying to say that the format of application, somebody has to apply from the government, get it, and then apply. Correct? That is your submission.
No, that's it. My only submission is that since at that relevant point
you
of
see,
time,
Mr. Bose, I have a very limited understanding and capacity to retain. Retentive capacity is very low. So once you start a matter, you finish it, bring it to an end. You are now saying that the application form must be applied for and got from the government. Please, my question is that, is it impermissible under any law that a format not downloaded or not received from the government cannot be used? Is that what you are trying to say? That is my question.
for obtaining application format, I have applied and I have repeatedly asked the
Where is your
competent
application?
authority.
Where is your application?
Application, I have verbally also, but repeatedly, because that for obtaining application format, actually,
the-
lordship, the
what is the
application
fees?
is not submitted, but
What is the
verbally we
fees?
obtain.
Okay, what is the
Verbally
fees?
we obtain.
What is the fees of application?
Application in the application format,
No, no,
there is
no.
a clear indication.
Application for getting a application form.
Yes,
What is the fees?
that is as per the discretion of the
Oh,
administration.
discussion.
Exact that fee.
Now, as a last question. Any nonsense more you have to say?
Lordship,
Any more nonsense you have to argue? You complete the nonsense first, then come to the pain point. For application form, you have to apply. For an application, there is a fee which is as per the intent of the officer. There are two submissions you are making, and I am responding it by saying that it's an absolute nonsense.
Lordship, I'm not getting.
You will never get it. You see, one who speaks nonsense will not understand what is sense. Is it under which law you have to apply before the government for an application form?
That is as per Arunachal Pradesh land.
Shows that the application
Land
has to be
Settlement
downloaded.
Records
Shows
Act
that, shows the provision. Mr. Tapin, the application form is required. It should be an official application form. Official application form.
Settlement Records Act law. If the land is government land also, then under section 12 lawsuit, deputy commissioner can give allotment to the lawsuit.
No. In order to apply, you need an official form.
Yes, the official form is there. The format is there.
No. Format is something else. My question to you is, to get that format, you have to apply before the government.
No. To get that format
Form.
application, no need to file any application.
No need to file
Just
an
you have to
application.
pay
No
10
application
rupees.
is required.
You just have to,
Yes, you have to pay the nominal fee of 10 rupees in the office and you have to collect it from the clerk only. There's a application form.
also application form, you sell it.
The deputy commissioner, office of the deputy commissioner.
They sell it.
Itself.
Where is this provision?
That is not here, no saving.
In this act, it is not found.
Then now suppose I type it at my home,
Lordship.
your office will not accept it.
Lordship, that will be accepted because it's submitted, Lordship. But
No, I
basically-
don't purchase a form from the government.
Lordship,
Then what happens? My application would not be accepted.
not accepted, they will be asked to file in a proper format. Because certain requirement is there also.
Oh, then we are not extending then we are extending the stay. If he's applying and you don't give him form, which is accepted, I was thinking it's a nonsense. But no, it makes sense. He's right. I was wrong. I made a wrong comment. Sorry.
There's no such.
You are admitting it that it is sold by the government. If he does not get an application, how will he apply?
No, that statement is not there, Lordship.
No, but he's making an oral statement.
He.
It
that
makes
statement
sense.
is not here, Lordship.
It makes sense.
The pleadings, Lordship.
You don't give him a form. If you don't give him a form,
No, in the pleadings, Lordship, that is not the case, Lordship. In the pleadings, Lordship, in the read petition.
I don't know what is happening. Come to page 6. I told you when I read. Come to page 6.
Page 6.
Line about 10. To add to the problem of the application is also untraceable from the office of the Deputy Commissioner. Finding no alternative remedy, petitioner has approached the office of the Deputy Commissioner with a request to furnish application form. However, the petitioner has been denied even application form. Is a statement on oath.
Lordship.
If that be so, then we are extending the stay. If that is the case, we are extending the stay. Your application, we are closing it. The Deputy Commissioner cannot take an advantage of that. We can't, number one, sell form.
Is phase 6, last paragraph, Lordship,
I get it.
where I have specifically stated.
No, I got it. But I
that
was under wrong impression. I made an incorrect comment. Sorry, I'm extremely sorry.
here, last paragraph is, Lordship, that after desperate attempt to obtain application form for land allotment, petitioner submitted a planned application. Because there is no remedy or alternate way out. If I am not giving.
Basically,
application-
Lordship, as a matter of practice, though it's
It
not
is admitted, my learned counsel has admitted.
No,
the
no.
fact.
Though it's not prescribed in the any Lordship, as a procedural Lordship, as a matter of practice, Lordship. Deputy Commissioner has no control over the selling of format, Lordship.
Of course, in the
It is
district.
the office, Lordship.
No.
The clerk is there, Lordship. They.
It's
Or
wrong.
you
It's wrong.
draw up a departmental proceeding against them. Who will sell a form in the Deputy Commissioner's office without his
It is the
knowledge?
concerned deputy
But that
commissioner who.
complaint has never been lodged before me, Lordship.
It's not a question of lodging. It's a question of fact which is pleaded in the writ petition.
But
And-
that has not been Lordship. Is there anything supporting the?
Once we admit it, we don't accept it. Then we extend the stay, we fix it for hearing.
Lordship, if Lordship see the application, it's page 25, Lordship. Page 25 is the Lordship applications filed by the petitioner, Lordship.
Yeah,
For
this-
allotment, Lordship.
Correct.
Here, Lordship, that sort of.
So where is your reply to that? Where is your response to the application? Where is the Deputy Commissioner's response to the application? What does he say?
Lordship, kindly come to my affidavit, Lordship.
Yes, we are there.
Paragraph 4, Lordship.
Paragraph,
Paragraph 4, Lordship.
paragraph
Paragraph 4.
4.
This is in reply to paragraph 2 of the writ petition, Lordship.
Yes.
The answering response begs to state in pursuance of the Honorable Court so and so, the hearing was conducted on so and so hours, wherein petitioner was given all the opportunities to prove his claim over the government land. However, he failed to produce any documents or records to substantiate his claims. Accordingly, the appeal petitions of so and so was rejected after following due process of Andhra Pradesh public premises so and so. That with regards to the issue made in paragraph 1 so and so, the answer is not stated The appellant's claim of possessing the enclosed plot measuring so and so square meters since 2009 was found to be false. Periodical satellite imagery indicated that the house existed only from 2019, contradicting the petitioner's claim of constructing the structure in 2009. The petitioner failed to produce any record of the application regarding his claim of submitting an application for land allotment in February 2009, which he claimed was misplaced. There is no record of any predecessor deputy commissioner allowing or permitting the appellant to reside on the said plot. The petitioner failed to provide any document or evidence to prove that he has not an authorized occupant, and his claim of possession for over 50 years is devoid of merit and liable to be discarded. The land concerned exclusively belongs to the government as per the revenue record. The petitioner's plain applications for allotment dated so and so could not be processed as the land was under government possession and the government quarters existed adjacent to it, which is evident in the site inspection report. The petitioner and his learned counsel have both admitted during the hearing that they do not contain the fact that the said land is not a government land. It is established without any doubt to petitioner as well as that the said land is a government land. Here, I would like to point out one thing also. Here, Lordship, our rejection to their Lordship application is not that you have not filed in the proper format. Lordship has seen. This has been Lordship. If Lordship see the photographs annexed by them also, their Lordship encroachment of the land of the government quarter, Lordship, the portion of government quarter, they encroach. Therefore, Lordship, our case is that Lordship, since you have Lordship encroach over the government land, therefore your application cannot be Lordship allowed. Lordship. There's not that we are telling him that since you have not filed in the format, therefore your application is rejected. That is not our intent. We've been to the Lordship, there is merit of the case, Lordship. As a matter of practice, Lordship, as I have submitted Lordship, basically format used to be their Lordship for applying Lordship. But in this case, Lordship, we have not Lordship objected that since you have filed in plain Lordship paper, and that application also filed in 2021 Lordship, not in year 2009 Lordship. From 2009 to 2021 Lordship, there's no records at all Lordship to show that if ever he had applied for land allotment Lordship, to 9 to Lordship 21 is 10 years Lordship. During these 10 years, if any document to show that he had applied for land allotment Lordship, nothing is there Lordship. 21 Lordship, that too after Lordship, the NIT has been floated in 2021 Lordship for constructions of the hospital building Lordship. In year 2021 only he filed application Lordship. And his rejections of his application not on the ground that Lordship, that he has not filed in proper format Lordship. And so far the allotment is concerned Lordship. This is another aspect. And the eviction proceeding is another aspect of Lordship. In writ petition itself, Lordship can see at page 26, Lordship. The writ petition, the photographs, Lordship. Here, Lordship, apparently we can see the government quarter is there, Lordship.
Where?
Page 26. This is the Lordship application, the rough statement prepared by the petitioner himself, along with Lordship in support of his application. Page 25 is the application for land allotment, Lordship. Page 25 is the application. And next page 26 is a supporting document. Lordship can see the
just a moment.
I'm in the writ petition.
Just a moment.
Lordship, yeah.
Just a moment. Yes, drawing is at page?
Page 25, Lordship. 25 is the application
Ah.
filed by the petitioner for land
Yes.
allotment, Lordship. In support of this application, Lordship, one rough sketch map prepared by the petitioner has been submitted along with this. That is at page 26, Lordship.
Yes.
Page 26, Lordship can find. Because he awaited the hospital is going to be constructed. That was already started by them. Then therefore, in his rough sketch map also proposed construction hospital. He knew that was and proposed a plot of commercial of Nyasam Junction. This is the petitioner Lordship. And Lordship will find the government quarter just in between the proposed hospital Lordship, the plot and the government quarter. In between, this man has encroached over. In his application in 2020 Lordship, he knew that the hospital is under construction Lordship. And this, therefore, this has been shown that this is proposed plot for the hospital building. And this is the sole application which is lying before the Deputy Commissioner Lordship. It was filed before the Deputy Commissioner. Apart from this, nothing is there Lordship to show that if ever he had applied.
Okay, yes, you're trying to say something. You're saying something.
That's it.
You're saying something.
No, Lordship, this hearing of this main petition, writ petition, my humble prayer would be, as I'm not fully prepared for this
No, no, you
argument.
see, we are asking for a stay. For stay, prima facie case has to be made out.
Yes,
So prima facie case, if you have heard, there's nothing more remains in the main case to be heard.
may I take your honor at your Lordship at page 23?
23.
23. This is the photograph of the entrance building of the District Medical Hospital, approach road. It is very crystal clear. There is an approach road. In spite of this approach road, it is motorable. Everything is there is a wide, big truck, even big vehicle can come. But my construction is down below. My house is down below in the left side. And this is the approach road. And they are now vindictively, they are single out me to evict my possessed land. Actually, my possessed, occupied and possessed land in question was not fit for human habitation. I have, for decades, I have cultivated ornamental plants, doing seasonal cultivations, and I have constructed culture house, and still it is the SPT house, OVT house is standing in. That is the record. That is the structure that I saw that I am in possession. And respondent number 4, till today, respondent number 4 has not whispered anything on their behalf that I have encroached an inch of land of respondent number 4. Because therefore, respondent number 4's affidavit is very much important to dispose this writ petition. So that is one part of my submission. And then again, may I take your Lordship at page 25 also, where my learned friend has said, this is a plain application. As your Lordship has rightly pointed out at in my writ petition, page number 6, wherein I have specifically stated that after desperate attempt to obtain application form for land allotment, petitioner submitted a plain application dated 24/2021 along with a rough sketch map for commercial purpose to the Deputy Commissioner Sanglang. And the said application was received and acknowledged and was marked to the District Land and Revenue Settlement Officer DLRSO Changlang. So there down below in my application, there is a signature of the DLRSO, that is District Land Revenue Settlement Officer Changlang. And this application has not been rejected. And it is pending before the competent authority before the respondent, and it is still under active consideration. Then may I take your lordship at last page? Last page is page 51 of my writ petition, annexure 9. Annexure 9. Now, the state officer, who is respondent number 3, have issued the eviction notice without hearing me, even after filing reply and waiting for hearing, but ex parte order was passed. And before this, and the first writ petition was filed before this honorable court, and that interim order, eviction order was quashed, and accordingly, the matter was again remanded back to the learned deputy commissioner.
Which page was the order?
51 annexure 9, the last page of my writ petition. This is the lordship. What I'm trying to convince this honorable court is that this is the application form for allotment of land in Changlang district. Here, the format indicates that serial number 5, occupation, serial number 5 is occupation, if any. Then serial number, lordship, serial number 12. If the application is for regularization, give particulars of the land with date of occupation. Date of occupation. And sketch map of the plot of land. This has to be submitted. Rough sketch map and the date of occupation has to be submitted. Meaning thereby, the land the government land, whenever we are supposed to apply for land allotment, we have to occupy the land first. Then, as per application format also, we have to get an application form, where in this instant case, I have even denied of my application form also, till that. Due to which I have submitted a plan application. Okay. So this is very clear. Then the state officer, they have now issued a so-called notice saying that I have encroached the government land. Unless I occupied the land, I have not encroached any government, any of the department's land in question. Neither the respondent number 4 is whispering till that. This is the second round of writ petition before this honorable court and before the learned affiliate court of deputy commissioner also.
Where is the order of the first writ petition? Where is the order of the first writ petition? First writ petition, where is the order?
First order, of course, it has not been enclosed here. First order.
Okay.
In my I had an next. This is at least 34 in my eye.
Page number?
135, 34.
54.
34.
34.
Okay. Annexure 8.
No. Yes.
Here, Lordship, my again, second point of submission is that why this writ petition is before this honorable court is that since the earlier writ petitioner disposed with a direction to afford a reasonable opportunity of being heard to the appellate court. Since the eviction order was issued by the estate officer without hearing me, without giving opportunity, then I have filed an appeal before the appellate court of Learned Deputy Commissioner. Learned Deputy Commissioner, even after fixing a date of hearing and time, and he went out of the court. He was attending some program. And after waiting till 4:30 p.m., I submitted an application saying that the next date, hearing date may be fixed. But without hearing me, expert day order was passed in my absence. And today also this second round of writ petition is that while hearing the matter, respondent number 2, who is the state officer, as well as respondent number 4, who is the medical department, DMO, they failed to turn. And respondent number 4's plea was very important. His pleading was very important. Whereas in their absence, the hearing proceeded. And even I have requested the Learned Deputy Commissioner, who is the appellate authority, who is respondent number 2 in the instant writ petition, to refer the record. But even without case record, the matter was proceeded. Even without going through the records, there is no record while the case matter was heard. Without hearing, it was now without appreciating my evidence, my documents, and without hearing the other side also. The respondent number 4, who is very much important in this instant dispute, because it is the respondent number 4 who is going to be affected by this outcome of this writ petition also. Till today, even after receipt of the copy also, they failed to file affidavit because their affidavit is very important. Unless that is your lordship, without their affidavit, these writ petitions cannot be disposed in the interest of justice because their affidavit is very important. Therefore, my limited prayer is that, lordship, since I'm totally not prepared to argue the matter, but however, the respondent has filed interlocutory application number 166 for vacation of the interim order, which was passed on 26/7/2024. This interim order, as your lordship has rightly observed, on 16/9/2017, whereby for invoking Article 226, Clause 3 of this Constitution, because in this case, in some case, Article 226, Clause 3 of the Constitution does not apply. This is the different situation where the opposite party or respondent has been given opportunity, they have been furnished with the relevant records, and they have been heard. Therefore, interim order passed on 26, this order which your lordship has observed on 16/9/2024 be altered or modified.
Mr. Boji, we have heard you on merit and the entire writ petition, including the interlocutory
And
application.
till such time, lordship,
Please try to understand, we have heard you in the merit of the writ petition, along with the interlocutory applications.
lordship, my only humble prayer is that till such time the matter may be fixed for hearing, and till such time the interim order may be extended by modifying the order dated 16/9/2024.
Okay, we'll pass orders in the chambers.
Lordship, just
Yes.
Lordship, partially when I say this writ petition, Lordship, There's a lawsuit so far, this eviction, this proceeding is concerned. That has been drawn under lawsuit, our particular act of 2023 also. Here lawsuit, the estate officer issued so cause notice. Then it was eviction order was passed. He filed an appeal before the appellate authority under section 12 lawsuit. The deputy commissioner, without lawsuit personal hearing of the petitioner, seems rejected the appeal. Then he approached the Honorable Court lawsuit. Then this Honorable Court, in observation that he was not personally heard, therefore the opportunity may be given and dispose of the matter accordingly. Then accordingly, he was heard lawsuit. He and along with his lawsuit counsel was there. He was heard. And very region order has been passed by the appellate authority. Now question comes here lawsuit. What right of the petitioner has been violated? The first question. Admittedly, the land belongs to the government lawsuit. Here is not case their lawsuit, they are asking for the consideration of his application for land allotment lawsuit. If lawsuit see the prayer lawsuit. So for the applications format is concerned, it's not the Malapati is not has been raised and without implementing one as a party lawsuit. Malapati cannot be considered a lawsuit. And even the allotment part, there's no prayer in the allotment part lawsuit. Now question is the lawsuit. What rights of the petitioner has been violated lawsuit? Was not he was a hard lawsuit? He was hard lawsuit. And what else are to be heard now? Because admittedly government land, no dispute. So therefore lawsuit, if lawsuit see my lawsuit application, when this DPR was prepared lawsuit, we are not deviating from the DPR lawsuit.
But do you know one thing? What shocks the conscience of the court is, in the very eyes of the deputy commissioner, his office is selling application form. Correct. What about the code of conduct rules? CCS conduct rules, what happens? Somebody is making earning out of a government job.
But here just one aspect.
No, it's not that. You better advise your the deputy commissioners all over the state not to do that. They can't earn from the poor people. He may be a rich man, but when he's applying for land allotment, he's a poor man. So if under the eyes of the deputy commissioner, such trading is taking place, in one of these cases, we'll call them up for misconduct under the Code of Civil Services Rule Conduct. It will be violative of that. Has he taken permission from the competent authority to sell forms in his establishment? Is the sale proceeds of the establishment going to the state treasury?
Lawsuit, only one submission on that aspect. Lawsuit, it is not the case, lawsuit, if this issue has been brought before the deputy commissioner, that he has not been given the lawsuit, the form. Had he ever raised it before?
No, that's why I'm not saying that we are passing orders in this case, but in one of these cases, when something like this comes, that a government office is not accepting private forms, and they are only accepting the forms sold by them, it will be a misconduct. There is a judgment of our High Court in these connections where forms were sold only in the prescribed photostat shopkeepers in Guwahati for this driving license. The court came down very heavily about it. They will accept photostat copies of driving application only from shop X, not from shop Y. This is a judicial pronouncement. They better advise them. Not in this case, but one of these cases, if such complaints come, that the government staff under the deputy commissioner's establishment are selling forms, you are deep into misconduct. Only I have to say two things. Number one, is the proceeds coming to the government treasury? If it is not, it's a misconduct. And number two, it is sold in the eyes of under the eyes of nose of the district deputy commissioner He's a party to it. He can't escape that. It is under his establishment.
What Lordship
He's
has
a
already
P-
updated is very correct, Lordship.
Better,
But what
better
I'm
transmit
just,
that.
I'm simply pointing out in this case, Lordship, this
No.
issue has never been raised before the Lordship.
No, you see, those things is not required to be raised in a writ petition.
No.
I am also sitting in the jurisdiction of equity. Once it comes that iniquitous actions are taken by the respondent, what happens to the case, I don't know, but I can issue a notice to the government to take note of these things.
Close.
Powers, when I use to exercise, can be exercised. Why should a citizen come and say that the government, the DC office is selling form and then he's not giving it to me? Something which is unthinkable for me. That's why I used harsh words on Mr. Bose, for which I have. This is the third time I'm apologizing to him.
But has it been ever raised before any authority?
It's not that. Why something has to be raised? Will the government start functioning only after complaints are made? What is good governance?
Lordship,
What is good governance after all?
Oh. Lordship, what
When
I've
it-
submitted is a matter of
No.
practice, Lordship.
No, don't
In
have that practice.
Minimum, Lordship, lay 5-10 rupees, Lordship, the poll.
Whatever, why 1 rupee also? Yesterday morning, when I was wearing my clothes, 1 rupee coin fell down. I spent 2 minutes time to find that out and pick it up.
Lordship,
Because in my community, money falling down from the hands is not auspicious. So even if 1 rupee falls down, I don't put my shoes over it. I find it out. For me, at that point of time, 1 rupee is very precious. So tell them to be aware. One of these days, if such a complaint comes again. Okay.
Then only Lordship, kindly see on merit, Lordship. The mere technical Lordship evaluation, deviation Lordship. How Lordship, it will Lordship, the petitioner substantive right has been violated, Lordship. Kindly this part may be shown.
Okay.
And other hand, Lordship, as I have submitted public interest. The matter may be disposed of.
I don't know, I'll take a call in the chambers. Mr. Bose has made a submission, you have also made. I'll consider if I can dispose of the writ petition or if I can only dispose of the interlocutory applications. Let me take a call when I go inside.
Standing counsel of respondent number 4, he also admitted that he will file with affidavit.
That's okay. We have already,
It's very important.
It's not even necessary for
we have heard on merit, we will decide what to
Because
do.
respondent number 2 is representing respondent number 2. He cannot represent respondent number 4. Because respondent number 4 is the interested and affected party. Who will be the affected party? Their affidavit is very important.
Here only, you are the writ petition, you are the affected party.
Yes. I am also affected party and respondent.
No, respondent number 4 is not. His interest is taken care of by the state under the, by the state officer.
No.
So he is no longer a necessary party.
So Lordship, actually, very tricky way. This impugned order also, within a half hour, within 30 minutes, we left from Changlang. I went from Itanagar to Changlang. We came
There is a
back.
judgment in 1995.
Yes. Within
Supreme Court-
30 minutes.
Please have some patience. Listen to me.
Lordship.
In 1995, there is a decision of Supreme Court of India. There, what had happened, and custom officer passed a 100-page order on the same day when he heard the matter.
But Lordship, here it was
No,
a
I'll tell you.
predetermined.
I'll
This
tell
is
you.
a quite
You are
mechanical
speaking
and prepared.
You are speaking of half an hour.
Yes.
In half an hour, the amount of work I do, if you ask my secretary, you will be surprised.
The moment I left the premises of the court, this
moment you leave-
this copy was
You
served.
see, not that. By the moment I take a 5-minute break in the court at 12 o'clock, all the orders passed before that, I sign it. You don't tell us the speed of
Sir,
work.
There is a,
In my courtroom, except for 2 days, I can understand. But if a third day order is not uploaded, I am aware of the list of which cases my orders are not uploaded. So within 2 days' time, whether the order is 5 minutes or 5 pages or 10 pages, in the principal seat, 70 cases take up. All 70 cases, I pass orders 50, more than 60% on the same day. So don't tell us how much time it takes to pass an order.
but
Correct. Now, do you hear us? There's a 100-page order passed on the same day the hearing was concluded. The appellate, the High Court interfered with the order saying that it was impossible to pass an order of 100 pages in a day. It went to Supreme Court. Supreme Court said that once an officer has passed an order of 100 days, 100 pages a day, it shows his exemplary work culture. And the Supreme Court presumed that the man would have been, there was a 3-day hearing. So he presumed that the man would have started dictating in the day 1 and in 100 pages, and Supreme Court put down an appreciation for the officer who has passed an order of 100 pages a day. So don't tell us. 5 pages, 10 pages order every day. In my online portal, look at it, you will find every order uploaded. Yesterday's only one matter, last matter could not be uploaded. It has been done today at 10:30. You check the timeline. You will not find a default. So don't tell us 1-page order they were dictated in half a day. Don't tell us.
Lordship,
It pinches at a bad spot.
yes, it is not on the merit.
No,
but
that means,
the way
no, that means you see, when I pass a 10-page order in open court,
Yeah.
and it is transcribed and uploaded on the same day, you will say that it was a typed order. Somebody gave me, Mr. Namam is there, he gave me the draft copy earlier. Don't tell us. 10-12 pages orders on the same day you find me uploaded when I pass an order. Don't tell me half a page order can be passed and uploaded on the same day. Don't tell us. I give you an offer. Stay with me for a day. Tolerate me for a day when I work. And then make comments. Do it for 1 day. You'll see stars. Do it for 1 day. Come to the court prepared with all the briefs. You prepare a brief for me. Tomorrow we give all the briefs to you now. Sit in the courtroom, read the brief, make a note before you go home. So don't tell us the amount of work we do. Nobody will appreciate. Everybody will think that we are just here spending time. But don't tell us. Don't tell us about the work. Because then every order I pass becomes questionable. How Justice Surana can pass 70 orders in a day, upload 60 of them? Somebody else is helping him. No, don't tell us. It's the worst thing I can hear.
Lordship, this is with regard to transfer and posting matters.
Yes.
Lordship, in this case, I have a very limited issues here. One is hardship in compliance of this transparent posting order, impugned transparent posting order, and another is violation of standing government guidelines for issue of transparent posting. Kindly see, Lordship, I have a son, only lone son, single son, that has been recently in the month of July 2024. There was a heart surgery, and I have been. I'm there at this Tirap district, and
You've been transferred where?
At the West Kameng district, from Tirap district to West Kameng district.
And my son is doing study at the class 11 student now at the
Only the illness of a son, howsoever serious it would be,
and that is
cannot be a
why
ground to stay the transfer.
that is why I am facing hardship, and I am regularly doing checkup as per the doctor advice to Haryana, where this operation was performed. In every month there is a routine checkup, and there is a nearest hospital is there is Dibrugarh, and that is why it is that is one of the this aspect, and another
But
is
only with the government, we can't do anything
lordship,
about it.
as per
Although-
the as per guidelines, this any this transparent normally this transparent posting is to be effected by the end by May of by end of the May of every financial year, so that before onset of the monsoon, the transfer may be effected, so that the government employee are not facing hardship in compliance of the transfer order, because I have a family and I have to shift my family in the far away place. And I am facing, additionally, I am facing hardship in compliance because my son is seriously ill. In this connection, I have lordship filed representation before the competent authority, which is yet to be considered, lordship. And this is this main contention is lordship, since government has to see the not only effective transfer to my this argument is government has to see the grievances of this own employee also while effecting the transfer. Therefore, I want alternative accommodation also that can be given by the competent authority only.
No,
At
you
this
see,
stage.
you are in a forest division.
Yes, forest division.
So it has to be an interior place wherever you go. You can't have a common place of post.
There are many. Namsai division is there. Devapani division is there. Nearby area. I may be accommodated if the authority wishes. That is why at this stage I would pray,
Yes,
Lordship.
Yes, notice may be issued, Your Lordship, in this station. And in his petition,
Who
Your
is the
Lordship,
competent? Where is your representation?
Lordship, kindly see
page 18.
and page 18, Lordship. On 23rd September 2024. Page 18, Annexure 2. That is where Lordship, impugn order may be stayed and matter may be disposed for appropriate
No, we
consideration.
are not
by
saying
repeat.
it. You see, there are two judgments of the Supreme Court. There is again one judgment of our High Court.
Yeah.
It says that once there is a transfer order, you have to comply with the order. We can't say don't comply with the order of the authorities. We'll only say that how much time your PCCF will take?
It was submitted on 23.
How much
and
time your
forwarding-
PCCF will take to take a decision in the representation? How many days?
I have to take instructions in this.
Huh?
I have to take instruction, Your Lordship.
No, just ask them how much time they will take to dispose of the representation at page 18.
Okay.
In page 18 is a representation.
Yes, Your Lordship.
Call them up and ask them how much time they want to dispose of the representation.
Yes, Your Lordship.
Come in some time and take up other matters.
Yes, Your Lordship.
Because we are in a difficult position. There is a vacation. So if we have to adjourn it, it goes for a month. Neither your purpose is served nor his purpose is served.
Yes,
So ask them whether how much time they will take to dispose of the representation.
yes,
Starting from tomorrow, how much time they will take.
yes.
Just ask them. Yes.
My lord, made this your lordship. I filed an application for modification variation of the order that has been passed by your lordship. Kindly look into my IA 180 of 2024. Yeah. Yes. Lordship will kindly see the impugn order 23/9/2024. Hello, my lord, before your lordship goes through the impugn order, just 2 minutes, 3/9/2024, there was a transfer order issued by the government, whereby my learned friend's client was a regular executive engineer. He was transferred from SEPA to RAGA. And I, vice versa, I was in RAGA in the rank of assistant executive engineer. And I was transferred to his place. Now, thereafter, he moves the High Court, he files a representation before the government. Government doesn't decide it. He comes, file a writ petition, first writ petition. There is a direction passed by the court to dispose of his representation. In the meantime, there was a stay order which has been passed. Now, thereafter, the authority decides the representation, rejecting his prayer. Thereafter, he approached this honorable court, and your lordship has passed this order at page 14, 23/9/2024. Now, my lord will kindly see. No, 1 second. Before let me start. I have started. Kindly see para 4. Relying on the decision of this court in case of Hibutama so and so, it is submitted law laid down in this case was an executive engineer who is holding such substantive post. Lordship got it? And drawing pay of his own scale cannot replace a serving superintendent engineer on transfer relying on the said judgment in the present period transfer of the petition against in charge executive engineer is assailed. Now, lordship will kindly see the main paragraph is 14 and 15 at page 17. Accordingly, notwithstanding that by copy of order dated 29/2024, which is produced by learned additional advocate general has shown that a petitioner has been released from the post of executive engineer SEPA division on joining in the said post by engineer Hilang Taju, which I am representing. The court is inclined to state the operation of the transfer order dated 3/9/2024, bearing number so insofar as officer serial number 2 and 3 concerned. Being engineer Hilang Taju and so respectively, the respondent number 1 shall pass consequential order to restore the petitioner to his earlier position that existed prior to issuance of the relieving order dated 29/2024, thereby relieving the petitioner. Till such exercise is done, no coercive steps shall be taken against the petitioner. 15 is important. Having noted, petitioner has remained in the same place of posting of 6 years, which is more than a normal tenure. The court is inclined to provide that this interim order shall not come in the way for the competent authority in the government of Arunachal Pradesh, Department of Urban Affairs to transfer the petitioner against any officer of the same cadre and or against the in charge executive engineer if such person is drawing salary of the rank of executive engineer. So relied on a judgment passed by this court. I have looked into the judgment of this court. Now my case is that kindly see at page 19. 19 kindly be look into my lord. This is the 24th of July 2024. In pursuance to the government notification dated so and so, as per the recommendation of Department Screening Committee meeting held on 30/5/2024, that is first, second, third financial upgradation under MACP. MACP, my lord, Modified Assured Career Progressive Scheme, is their pay is regulated, is hereby granted to following officer completion of 10, 20, and 30 years of continuous service. Accordingly, the pay is hereby regulated under FR 22(1) as tabulated below. Now, lordship will kindly mark serial number 1. This is the private respondent. Present pay is 73,200. Pay after granting of MACP is 76,200. That is level 11. Now, date of effect of financial upgradation 8/7. So and so. Now, there is a financial upgradation. Now, if your lordship kindly turn to page 20. Now, your lordship will kindly mark in page 19, which I just referred. This is the pay scale of the executive engineer. How it is a pay scale of this executive engineer? Level 11 is the pay scale of the executive engineer, L11. How you find L11? I'll show it. Kindly see page 20. Now, this is 15th of July 2024. This is the recruitment to the post of executive engineer. If your lordship kindly see 1. Short title and commencement. This rule may be called a recruitment to the post of executive rules 2014. Lordship got it? They shall come into so and so. This rule. Now, lordship will kindly see 2. These rules will apply to the post as specified in column 1 of the schedule annexed to these rules. Number 3. Number of posts, classification, scale of pay, number of posts, their classification and pay band, grade pay, pay scale attached thereto shall be specified in column 2 and 4 in the schedule aforesaid. Now, if your lordship kindly turn to page 22, this is schedule. Kindly see name of the post, number 1, executive engineer, lordship got it. Now, kindly mark pay band and grade pay and pay scale PB3 15600 39100 and GP is grade pay 6600 per month. Now, kindly turn to page 23. There is a table. 23, next page. Table 5. Now, if you see pay band, if your lordship goes 1 to 3rd column, is 15600 39100. Which your lordship will find at page 22. 22, where just your lordship will kindly pay band and grade pay. Your lordship will find 15600 3910, which tallies at page 23. Lordship got it? Now, this is immediately thereafter. This is the grade pay which your lordship is 6600. Your lordship will find at page 22. 6600.
Yes.
Lordship got it? Please go down below. This is after 25, it is 11. Level 11. 11. Now see 1 index 66700. Now the pay scale which I am receiving is 76,200. 76 after 67, 1, 2, 3, 4, that has been, there is an increase of my benefit which I've got, 76,200, increment which I got, 76,200. Lordship got it? So I am drawing the scale in the rank of the executive engineer. Now what I have seen, the judgment of this court, which your lordship expressed, both the judgment relying on the judgment of the of a learned single judge, to the extent that whether it can be replaced by a regular executive engineer, because your lordship has indicated that. That was a case, Hibatabu case was the superintendent engineer, where an executive engineer was replaced. He was again taken as a superintendent engineer, but he was not a regular employee. He was holding the post. But the court said whether he was getting the salary in the rank of superintendent engineer or not. That was the case. But here is a case, and in this case, the court said he is not getting it in the rank of superintendent engineer. And a reference was made to another case of 2016 of Honorable Justice of this Honorable Court. And that also indicates our executive engineer. That also says that it can be replaced, but there are two conditions. Either you replace by a regular employee, regular executive engineer, or he should draw the same, this pay scale in the rank of executive engineer. So what your lordship indicated is that if I can show before this court that I am getting the salary in the rank of executive engineer, then my lord, I think government was right in transferring me in his post, because this order, kindly see, is at page 19, is 24th of July 2024, where it indicated my level 11. And the transfer order was passed after that, 3/9/2024, 2024. 3/9/2024 is a transfer order. Lordship looks into the transfer order. Is at page 24. 3rd of September 2024. Which page? Page 24 of the writ petition. This is 20 impugn order. Your Lordship is at page 24. IA also I have annexed in the IA. Page 14. 12, I think, 12. Is a transfer order at 12. Now, the question here, my lord, will kindly see 12. In my IA also 12. 3rd of September 2000.
3rd September.
3rd September. And why? Because 10 years I have qualifying service. Now, there is no DPC is being held. That's the whole problem. That is why the benefit I got, the modified, the career progressive scheme, I got the benefit out of it. So in that view of the matter, my lord, your Lordship has observed that if this petitioner, the respondent can show before this court that either it has to be a regular executive engineer or I am getting the scale in the rank of the executive engineer, which your Lordship indicated. If your Lordship looks into this order, yes, impugn order, that's what is indicated. And the last at page 17, a paragraph 15 last. 15. Or against in charge executive engineer if such person is drawing salary of the rank of executive engineer. So, my lord, here I have joined. My joining report is 28th of September 2024 at 25. Already I have joined. He has been released. Already he was released. And I have joined. Because of the interim order that has been passed by the court. And your Lordship, what your Lordship has indicated. Lordship has not stayed. Like Lordship was inclined to stay. Kindly see. Has been released. That was indicated in paragraph 14 also. On joining in the state court, but there will be a liberty has been given. But only I came up for modification before the court that I have been drawing salary in the rank. So I think, my lord, is a case where my humble submission is that I should not be displaced. Already I have joined in his post.
Yes,
That's my submission. Yes.
Well, as a matter of courtesy, I interject, sir, saying that, sir, before proceed, kindly give me 2 seconds to make a submission before the court. Well, I have been handed over a brief at 10:30 when I reached in the court. So I have filed my power. So that is first thing, which I wanted to indicate that, sir, when sir said he wanted to communicate. So anyway, sir, as a matter of courtesy, it's my duty. So to show my greatest respect, sir. The secondly, my lord, the proposition which the senior counsel has raised, as a matter of practice and procedure, I need to file my counter on this. Issue notice in the IA, my lord. I'll file 1 week.
No, there is no problem, but this, I should not be disturbed, my lord. I should remain in that.
No, my lord, that, sir.
That's my,
sir,
my humble. Otherwise, today there is been protection. That should be modified to the extent I should not be disturbed from where I am there. I am still holding that post. That's all. My lordship will issue notice, no problem.
In the IA, I will file my objection and I will distinguish, because I will distinguish certain things, my lord. Because whether the applicant in the IA, petitioner in the IA, is holding a substantive post of executive engineer or not. Because I was the counsel in Hibutama. That was conducted by means of virtual court. It took 2 days to conclude the argument. I know the facts in this case. I'll distinguish, my lord. As a matter of practice and procedure, my lord. I lost, my lord.
Himutama,
the same
Himutama
ground
case,
sir,
before I came to the court, I read the entire judgment.
Sir, anyway, as a matter of procedure, my lord, kindly grant me 1 week time to file my counter and then we can finish off the entire
No,
case
there
on
is no
merit.
problem. But the only
No, my lord,
difficulty is,
no, my lord.
my lord, modified to the extent that I should be allowed to.
I would be deferring with my senior counsel, my lord. With
No, but,
greatest respect, sir. With
But
greatest
this law has
respect,
been
as a matter
settled.
of procedure, my lord, under
No, but
226B, my lord.
otherwise, where I will go, my lord? That's
No.
the interim order that has been passed.
Sir, that is,
but-
I respectfully agree.
Yes,
Under
yes.
226 clause 3, my lord, notice has
Based on
been
which I
given
have
to me.
sued, my lord.
So therefore, I will
Based on
file
which
the
I have sued.
opposition.
Or sometimes it has to be stayed.
I'm sorry.
For sometimes this order of operation of the order has to be stayed.
Yes.
You will file your affidavit by when?
I'll file it by Tuesday.
By Tuesday.
By Tuesday.
So next working day would be Thursday.
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 If they files rejoinder or convenient to the sir.
No, I am not there. You give me there. I argued the matter, my lord. Only what my request, humble request, my lord. If he is there, let it be, but I should not be disturbed. That's the thing. Because already, my lord, I have joined. I have joined, my lord. And your lordship has not stayed the order. Kindly see, my lord.
No, it is
That
stayed.
your lordship has not. Kindly see what your lordship, if I am not wrong, my lord, kindly see.
It's okay, I will pass an order.
Yes.
In the IA. But
Yes.
Mr. D. Das, Learned Senior Counsel, assisted by Mr. K. Mohammed, counsel for the applicant. So the applicant is the respondent number 3 in the connected WBC 429 of 2024. Also heard Mr. T. Tara, Learned counsel for the opposite party number 1. Who is the writ petitioner in the connected WPC 429 of 2024. We've also heard Mr. Arash Nawab, Learned Additional Advocate General, appearing for the state respondent number 1. 1 and okay, 1 and 2. Okay, only 1. Okay, 1. The by filing this interlocutory application, Mr. Nawab, you have to anything to say? You have anything to say?
IA is by the private respondent, my lord.
No, it's okay.
Metrics, as per the different rules, madam. So, my question, madam, the transfer order is not nothing from the.
No, since I have heard Mr. Nawab, if I don't do it, it'll be incorrect. So that's why. Next paragraph. This interlocutory application has been filed for modification of the alteration of the order dated 23/9/2024, passed in WBC 429 of 2024. On the ground that the petitioner, sorry, the applicant is drawing salary of an executive engineer, which could not be pointed out before the court on the tasks on 23/9/2024. Next paragraph. Issue notice. Returnable on Thursday will be 3/10/2024. You have the copies? You have the copies?
Yes.
No.
Yes, submit the copies.
Yesterday it was served.
No, it's okay. Post of the learned counsel for the opposite party. Oh, no, he's for opposite party number 3. For opposite party number 3. Suppose that you would make an endeavor to file the affidavit in opposition by 1/10/2024.
Correct.
Post of accordingly list on 3/10/2024. Next para. Till as an interim measure until the next returnable date, the operation of the order dated 23/9/2024 passed in WBC 4-9 of 2024 shall remain suspended. Full stop. Next para. However, the interim order is subject to further orders that may be passed in this modification application on 3/10/2024. List on 3/10/2024.
Only once we lordship indicated that I have joined on 20th September 2024.
We are not saying anything.
No,
It's
that
not
has
be
been
implemented.
released. Correct. I'm sorry.
We are saying that this order will not be suspended.
Hmm.
We are suspending this order.
Suspending which order? Your lordship is suspending which order?
The order of the writ petition.
Oh, acha. Your lordship.
No, my lord,
suspending.
my lord, may I just
Okay.
make a request?
Okay, sir.
Since I have made the appearance just today only,
Okay.
but without affording me an opportunity, what is envisaged under Article 226 Clause 3, it would not, to my understanding, my lord, with greatest
No,
respect.
but you see, the fact is
Because, my lord, in the interim order, my lord, liberty has already been given. If the state feels that, if another officer
no,
who
you
is
see,
of the
Mr.
same,
Tara, whatever order I pass would be an order without hearing you. Supposing I say the
my lord,
manner which you are
then fix
suggesting.
it tomorrow for final disposal, because
Tomorrow I'll not
it is
be there.
big.
Incidentally,
No,
tomorrow I'll
no,
not
my lord, no, my lord, by my respectful submission, it is a big embarrassment to me. For the reasons that I made the appearance just now, and I have not gone through the brief properly even.
No.
And then, my lord is modifying the order
No, I'm
without
not
complying
modifying,
with the
I'm suspending
requirement
it.
under 226.
I'm suspending it. I'm not modifying it. I'm suspending it.
Yes, my lord.
It's not a modification. If you think you are a modification, then I have nothing to say.
My lord, consequences.
If Mr.
my-
Tara would
my lord,
think, if Mr. Tara would think staying of the order is modification.
My lord, I'm just humility, my lord, on the lighter vein, my lord. Here, my lord has pointed out, state is a welfare state. The government is supposed to get everything free. In previous case, my lord had pointed out. My lord, forms are sold at 300 rupees. Same thing, if my lord gives this interference, tomorrow the order will come. Tomorrow the order will come that I have been grieved. Then my filing of my read petition will become infractions.
No. You see, we are just staying the order. We are not determining the rights of anyone. How can somebody be aggrieved by that?
Staying, my lord, the interim order passed.
Yes. It was an interim order that is suspended. He's now showing that he's getting a salary of the paper.
No, my lord, kindly record this then. I'll make a submission. I'll make a submission on this particular point. Fact has been distortedly presented in this court. One, paragraph 4, clause 4 of the Himutaba case talks that if a similarly situated officers only can be repressed. The person in his appointment itself has said, my lord, that he is assistant engineer. He is not holding the substantive post of executive engineer. If a person is not holding a substantive post of executive engineer, whose pay scale is 6,600 basic, and the assistant engineer is 5,400. What is Qadr, my lord? The definition of Qadr comes in that way. He is assistant engineer because the senior counsel has fairly submitted that DPC has never been held. DPC has never been held. Because of that, the promotion could not be affected. So therefore, that modified assured career promotion scheme was introduced, so that a person being deprived of the promotion can get the financial benefit at least. So therefore, nowhere he is holding substantive post of executive engineer. And these pay level 11, this is not the correct picture. It is on the recommendation of Departmental Promotion Committee. So therefore, Miller, these cannot be lightly interfered in this manner. I'll demonstrate from the read petition itself, Miller, just although I was busy on the leg in the court too, Miller. No, he's not here. No, in the I itself, Miller. Page 19, kindly come. Page 19, Miller.
Page 19, yes.
Page 19. I never expected this kind of presentation in the court. May I kindly read this, page 19. In pursuance to government notification, dated OM number so and so 2019, and as per the recommendation of Departmental Screening Committee, and held on 30/5/2024, the first, second, and third financial upgradation under MSCP. What is this word, Miller? Is there a word promotion? If that person is promoted, then there will be a separate order. On the recommendation of Departmental Promotion Committee, the Governor of Arunachal Pradesh is pleased to promote following assistant engineer to executive engineer. These modified assured career scheme promotion, my lord, this is only a financial benefit, not the substantive promotion to the post of executive engineer. Therefore, my lord, on this count, these kindly see serial number 1, my lord. I demonstrate from the facts itself, my lord. Kindly see Ilang Taju AE, my lord. What is his substantive post? He is assistant engineer. Assistant engineer. The pay level 10, he is drawing pay level 10. The executive engineer is of pay level 11, my lord. He has been given these financial benefit only because there was no DPC. The DPC could not be held because there was no vacant post where he can be promoted. By means of this small financial benefits given to a person, does he become an executive engineer? Respectfully not.
No, nobody said till now.
No, that's why, my lord.
No,
My
nobody-
respectful submission is,
Mr. Tara,
let it be there till.
Nobody has made a submission that he has become the applicant has become an executive engineer. The question is under that judgment. The requirement is that he must either be in the.
No, my lord, that I respectfully disagree. I'll distinguish. My lord, kindly come to para 4, clause 4 of that judgment. Justice Ete was along with me. Justice Ete was the another counsel for the state.
What is the citation?
Citation is 2024 GLT 503, my lord. 24 GLT 2020 4 GLT.
Just a moment.
Page 503.
2020. Volume?
Volume, my lord, 4.
We have the book.
I remember everything, my lord. I have dealt.
Yes. Para 4.
Yes, my lord. Para 4, my lord, this thing, Roman 4 also, my lord. Roman 4, my lord. The respondent number 1 contains that it is a fact that the state respondent number 2 was allowed to look after the charge of superintending engineer on temporary and functional basis. Mane here, my lord, he was given full financial benefit also. By order dated so and so, and was posted as senior surveyor of work SSW in office of chief
Which
engineer.
paragraph?
My lord, para 4, Roman 4.
Para 4, Roman 4.
Yes, sir.
The respondent number 1 contents.
That it is a fact that the respondent number 2 was allowed to look after the charge of superintending engineer purely on temporary and functional basis by order dated 07/06/2018 was posted as surveyor of works SSW in office of chief engineer rural works department Eastern Zone. Itanagar. So is the petitioner who was also promoted on officiating basis in the post of superintending engineer wide order dated 21/06/2011 and is yet to be regularized as superintending engineer. The respondent number 2 was allowed to look after the charge of senior surveyor of works on the functional basis with the approval of the competent authority as he was senior most executive engineer in rural works department and eligible to be promoted to the post of superintending engineer. Now, kindly see, fact is similarly situated in my case. Here, I am a substantive, I am a regular executive engineer. At Raga, he has been allowed to hold the charge of executive engineer. He should be grateful to the magnanimity of the government showing him the favor. He is not similarly situated officer, my lord. So therefore, then, my lord, kindly see. There is no quarrel on that tenure, my lord. Even in fact, the respondent in the read petition, my lord, has only, this is which line? 1 year and 4 months. The petitioner, the petitioner in the IA has completed 1 year and 4 months. It shows there is a involvement of a blessing of the political leaders. This is not that. I do not know, my lord, I have not gone through the read petition. Whether just I was given at 10:30 the IA interlocutory application. Since the judgment is known by me, is conducted by me. My lord, come to para 12 where I have argued the matter. Yes. The stand that I took, that because I was representing the para 12. 11, 12. No, 12. Where is 12? All those Govardhan Lal, every. My lord, kindly come to page 519. On the same fact and the proposition of the case, I argued this, but my argument was not accepted by this honorable court. And thereafter, the basis for interference, finding of this honorable court was that since he is substantive post is assistant engineer, and the petitioner's post, since the petitioner post is a substantive post of an superintending engineer, and while as a respondent number 2 in the read petition, in this case, my lord, I was only given the officiating promotion with financial benefit. But here is a case, he has even not been given as an officiating promotion. He is in charge, his substantive post is assistant engineer. Well, kindly see, Mr. T.T. Tara, learned counsel, appearing for the respondent number 2, while appearing for the respondent number 2.
But what in the order? In the order you will find E in charge.
No, my lord, it is not that. Not similarly situated officer. All those arguments, my lord, I said even I referred to FR 11 also. I cannot agitate. That I am aware of that judgment which my lord has referred to. Once transfer order is issued, I have to comply and join and then come. That is also our division bench, our high court judgment only, my lord. And the apex court judgment is also there. But sometimes what happens, my lord, all the authorities varies from fact to fact and the circumstances, my lord. Here is just, that is deviating from that particular fact and circumstances for the reasons that, my lord, the person who is not a substantive post, who is holding substantive post of executive engineer is replacing me. But second thing, my lord, the consequences that would fall would mean, my lord, we'll see, there may be some senior. Because, my lord, two things is very important. First, the seniority list of the executive engineer is important. One, as to determine whether Thus, mere granting of modified assurance career promotion scheme, extending financial benefit to the applicant in the IA, fortifies his claim that I am an executive engineer.
No, it supports the contention in this judgment. Hibutama. If he is drawing a salary of equivalent to that of the post.
SC also. No, Miller. He was just officiating promotion. He was given the charge, officiating promotion. He was also drawing the same salary of the executive engineer, assistant as a superintending engineer. Miller.
In this case.
In this case. So here is the case, these gentlemen, he is not drawing the salary of the executive engineer on officiating promotion.
You
That was in the case of officiating promotion.
Come to the operative part. The petitioner
Yes,
enjoys the
539.
position and status.
Let us go together.
The petitioner enjoys the position and status, including pay and allowances attached to the superintendent engineer. Whereas respondent to has only been allowed to look after the work of so and so. Temporary cases and the administrative efficiency and his own pay scale of executive engineer. So this makes a difference.
Yes, executive engineer, my lord. He was given the officiating promotion in his own pay of scale. Here, this man also his substantive post is assistant engineer, and he has been granted financial benefit under MSCP. Distinguishable matter of fact, is a similarly situated case, my lord.
Pay band is 11.
No, my lord, that is not. That's not counted. Suppose, my lord, in the High Court, there are two things. One is additional judge, another is a personal judge. Can a additional judge would be able to replace the position and status of a personal judge? Respectfully not.
You see, you are asking a proposition which is unthinkable. Because you see, in the High Court, that is not the consideration. It's not a routine.
No, my lord, please do not take that.
No, it's not that.
Please do not take it otherwise, because I gave an example.
No,
I'm sorry, but if this has hurt, my lord.
No, it's not a question of hurt. I am not an additional judge to be hurt. Now you see, the reason is that the question itself is incorrect. The reason being, a transfer of a High Court judge is never vice so and so. It is always an independent transfer.
It's not, my lord. Whether it is the Chief Justice, except he being the Chief of the High Court, will be a master of the roster. Nobody can question.
I'm not saying that.
But in terms of judicial power, all the
transfer
judges
of
have the same power.
No transfer of a judge is made.
No transfer is made. I agree. No transfer is made, my
So
lord.
you show an equivalent.
Except it is the roster where this bench
No,
is.
I'm not concerned with the power of the Honorable Chief Justice. That is beyond my scope of examination. The fact is that a transfer in this case, Para 62 explains it.
Let us read together.
Yes, yes, sir.
And I request Das sir also to go through.
With greatest respect, I respect him. I have read the entire judgment. What I have understood the judgment, I don't differ with he was the counsel. I read it. And exactly what I told when I'm moving the matter, it depends on your scale, whether you have received or not. Then only, because here is a case of superintendent.
Let him complete this part. Let him complete this part.
Yes.
My lord, I will request the additional AG to come up with the record of a cadre. What is cadre? And seniority list of assistant engineer. My lord. List of assistant engineer and seniority list of the executive engineer. Then because he made an observation that he is drawing pay level 11 and he has become executive engineer.
What you are asking is impossible. It is nobody's case that Mr. Das has entered the cadre of Mr. Tara. Nobody's case.
But then
even the AG did not tell that Mr. Das has entered your cadre.
No, learned additional AG has made a categorical submission. In view of he drawing financial benefit in level 11, his substantive post would be executive engineer.
No,
How that proportion is agreeable?
He never said that. No, no, he never submitted that. Don't put.
No,
words
that
in
is
my
what,
mouth.
no, my lord,
submit.
whatever it is, because I
Please.
heard, if I have overheard, I'll replay this video, my lord.
Yes, yes, do it.
I'll do it.
You do it.
Yeah.
Because his submission was
Yes, my lord.
that.
And if there is any infirmity I have found, I'll never hesitate to say sorry also. I'll say.
No, no.
Because
You see,
I heard,
Mr. Tara,
my lord.
don't take us to a place where I what do you call, I retaliate. You see, the submission of Mr. R.S. Nawam, the additional advocate general was that if he is drawing a payment of 11, then the government has done no wrong.
Yes.
That is his statement. You want to replay the video?
No, my lord, kindly come to.
You want to replay the video?
No, my lord. I'll distinguish from para 62 only.
No, no, I have a YouTube here. I'll show it just
No, no,
now.
my lord, just I made this statement that
No, no,
what
don't
I
put
have
words.
heard. No, no, my lord, please do not take it otherwise. Sometimes in court proceedings, my lord,
a
the
brief
bench
is-
also, the bar also, sometimes we loses the
a-
cool, my
A
lord.
brief is only a brief.
So unless, my lord, there is a no cohesiveness or amity between bench and the bar, the conduct
No, I'm
of
not on
any
that.
case will
But
not
Mr.
be
Tara, I was to
perfect.
remind you that a brief is only a brief. But for that, you don't, what do you call, put words to the, on the mouth of Mr. Nawab, which he never said. It's
No, no,
nobody's case. Nobody-
no, my lord, what I presumably heard,
He
I'll
never
use
said
the
that.
word. My lord, kindly come to this line. Page, the right side, page the 539, line 1, 2, 3, 4, 5, 6. 6 line, my lord. 6 line, my lord, right.
Yes.
In the instant case, like in WPC number 257 AP 2016, the relative merit, capability, conduct, and integrity of the petitioner vis-a-vis the respondent number 2 have not at all been examined by this court. What has been examined here is the position and the status the petitioner and the respondent number 2 occupies. The status is, I am executive engineer, he is assistant engineer. No dispute on this proposition. Occupies the department to find out the correctness of the interstate transfer made. On examination of the proposition and status of the petitioner and the respondent number 2 in the department, it is found that the petitioner and the respondent number 2 are not similarly placed officers in the department.
Complete that part.
Yes.
It's not stop here.
No, that is the court is giving the finding now. Sir, I will complete it. Don't worry. Sir. I'll complete. Sir, don't worry. The petitioner enjoys the position and status, including pay, allowances attached to the superintending engineers, whereas the respondent number 2 have only been allowed to look after the work of superintending engineer SSW in the office of the chief engineer, Eastern Zone, purely on temporary basis as a stopgap arrangement in the administrative exigency of the department in his own scale of pay, executive engineer, which is the substantive post of the respondent number 2. Now, my lord, here the modified assured career scheme granted to the petitioner in the IA is nothing but a financial benefit, has conferred no status or the promotion to the private respondent, so that he become at par with my status. So therefore, my lord, my respectful prayer, since first time I am making the entry appearance, 2, I should be given a fair opportunity to file reply, which I have raised and which I intend to raise initially in order to fulfill the objective of 226 clause 3. Issue notice, then unless if the order, interim order which was passed earlier, my lord, unless it is not very grave in nature or it violates basic fundamental principle of the laws, then my lord has to review it by giving the reasons.
So stay of the.
So therefore,
order
my lord,
according to
what I am proposing, my lord, give me a time. I'll come tomorrow also. I'll come prepare and argue. Where is the harm, my lord? If that is be the case, so my lord, kindly, my lord, equity. And that, my lord, I need not to say, the moment there is a violation of administrative principle of law, the equity which has fallen from the Chancery of England today, which we are following under 226, my lord, will be defeated. If my lord suspend this order, my lord. Can you record this, my lord? I have no problem because whatever it comes, I have to accept. Because
Okay.
after all, it is my lord who will.
Opposing the prayer for interim relief, comma, the learned counsel for the respondent number 3, opposite party number 3, has submitted that the projection of the applicant in this application, that he is drawing a salary of pay band 11 of payment of L11 of rupees 76,200 and the grade pay of rupees, what was the grade pay?
6,700 page 22.
Page
22.
a grade pay of rupees
Name of the
6600 does not confer the applicant the status of a executive engineer. Rather, comma, the financial advantage was given only because the government did not hold a DPC on time and therefore grant of MACP to the petitioner and the pay matrix of L11.
To the respondent.
Oh, sorry, to the applicant. The applicant. Cannot be said to be a, it cannot be read to be a substantive promotion of the petitioner to the post of executive engineer. Full stop. The learned counsel for the applicant has further stated that as he has entered appearance for the first time, he should be given a reasonable opportunity to contest this application, and any modification of the interim order at this stage would be denial of equity to the opposite party number 3. Full stop. Referring to the decision of this court in the case of Hebrew Tama, SE versus State of Arunachal Pradesh and others, within bracket, 2020 within bracket 4 bracket close GLT 503. It is by referring to paragraph 62 of the said judgment, it is submitted that notwithstanding that after grant of MACP, the applicant is drawing a salary of pay matrix L11, he would remain in the substantive post of an assistant engineer, and therefore, by referring to the said paragraph 62, it is submitted that the applicant would still be not of the same status of that of the petition of the respondent number 3. Next paragraph. Be that as it may, That same interim order. Okay. We are maintaining that same interim order of stay of operation of this order.
That will not, then will not list this along with the main petition. No need to list on third.
Don't,
Because
you see,
filing of the purpose.
don't express your annoyance. I am not.
No,
taking-
I am not expressing nothing.
You don't teach us when to list a matter
not-
and not to
No,
list
sir,
us.
respectfully, my lord, I am not doing that.
No,
What
please
I'm
don't do
doing
it.
is since
Don't do it.
Since the purpose of filing the writ petition, my lord, objective is done
Please-
away with.
Please don't express your annoyance. I'm not there here to listen to it. If you want to influence the court by showing an
I'm
annoyance,
not influencing, my lord. With greatest
No.
respect, my lord.
don't do it. Don't do it. Yes.
But then kindly accede to my prayer, my lord, at least list this along with the main petition.
You can make a prayer, that's
Yes.
okay, but don't tell us, don't
No,
show your
I-
annoyance and then tell us
No, my lord,
what
maybe
is this and do that.
the loudspeaker,
It's-
sometimes the voice might have come
No.
louder.
Mrs.
In any
Tara,
case, I am having a loud voice, my lord.
Mrs. Tara, we are not, have I ever commented on your voice?
No, my lord.
Anytime.
I'm admitting that because of my loud
Anytime.
voice.
Rather, when I see you in the court, whenever if your matter is not there, I look at you and smile at you, right?
Right, my lord.
Then don't show your annoyance to the extent that there is a distance which grows between us.
No, my lord, just if my lord permits.
No,
See,
no.
like there has to be a.
That's why I told you
coherence
before
between
you
the bar
began,
and the bench.
before you started to outburst, we told you a brief is only a brief.
No, in any case, see, my lord, whatever has
It's
fallen
a
from my lord,
brief
I have
only.
to accept it because there is no way out.
Yes.
And
If
we
you-
are council, we
if you-
are performing our
If you
duties
think
only.
that by retaliating or by showing your annoyance to the order passed, you can have a order modified.
No,
And
I cannot.
So when
And I
very
cannot
sorry.
influence the court also,
I'm very
except
sorry.
for performing my duty on behalf of the client since I have.
No, it's
signed the
okay,
wakalat.
but you see, you did
That's-
three
that's all
things.
right, in any
You
case,
did
stop.
three things. Number one, you put some words in the in the mouth of Mr. Nawal. And incidentally, although my memory is very weak, I have a very short memory, but I remember his utterances, his statements verbatim. That's why I made him, I asked him specifically, and therefore I remembered what he said. So don't do it.
I only.
You want the matter when?
Huh? Where it is fixed? 2210. It is already fixed on 2210.
20 to 10, okay. List on 20 to 10, 2024, comma, as agreed to by all sides. Yes.
At this stage, I was praying for lordship,
Yes.
interim order may be passed and,
Just a moment.
direction may be passed for disposal of the.
No, just a moment. Mr. Hiram was there. Just see Mr. Hiram is there or not. Mr. Hiram, you have come.
Your Lordship, I have received the instructions, Your Lordship.
Yes.
Till date, they have not received the representation dated 23rd in the office. I have been informed that.
Yes.
And Your Lordship, second thing is, Your Lordship,
You ask your petitioner. And how much time today? Let us say that we give you.
they
a
have
copy today.
told me that within 10 days, they will dispose the representation, Your Lordship.
10 days.
Yes, Your Lordship.
Okay. We give you 2 days time by tomorrow you give a representation to the authorities.
Day after tomorrow.
Day after tomorrow, we don't know
we-
whether the office will be functioning or not. Give it tomorrow.
It will be holiday, Your
I
Lordship.
will try.
No try. Though then orders will not be implemented.
Maybe after, within 2 weeks, lordship, at least, within 2 weeks, that may be disposed of, lordship. Because
Within
you
2
will-
weeks.
Within 2 weeks.
Oh, no, then we'll reject your prayer. You want to give an representation, you need 2 weeks
Representation
time.
already pending, lordship. Kindly
He
No,
says
Your
that-
Lordship, I
please
have
hear
been-
him. He
Yes.
says that representation is not in their office.
We have not
Kindly
received.
see,
Your
that is a completely lie, lordship. Kindly see page number 19, lordship. Annexure 3.
This is the forwarding letter given to the Chief Conservator of Forest by the Divisional Forest Officer, Consa.
I can make you understand.
Your Lordship, I have been told that this
You must
representation.
go to their office.
Yes, yes.
So
I will
if
file
if you
fresh
even
application.
if you have given it to DFO,
If-
does it prove that
Yes.
the commissioner has received it?
Yes, if necessary, I will file fresh representation, Lordship, before the competent.
Give it by tomorrow.
Yes.
Yes, Lordship.
This the government advocates here are all tested and tried. When Mr. Ram makes a statement, I respect it. The reason is that I have never found an opportunity where he has misled me anytime. So he says after getting an information that the office has not received it,
Yes.
we have to accept it.
All right.
That is why you see at a certain point of time to some council, I don't ask questions, I don't, sorry, when they make statement, I don't have to read the brief. They are so reliable. Mr. Ram, I've never found him till date. He's made any attempt to mislead me at any time.
Thank you, Your Lordship.
I heard Mr. T. Tapak, learned counsel for the petitioner, and Mr. Y. Ram, learned government advocate appearing for the
All the
respondents. Next para. The transfer and posting order dated 13/9/2023 is assailed in this writ petition filed under Article 226 of the Constitution of India on the ground that the son of the petitioner, who is studying in class 11, is suffering from cyanotic, cyanotic, cyanotic congenital, congenital, heart disease, requiring him a regular follow-up with the doctors at Dibrugarh. Full stop. Next para, the learned counsel for the petitioner has submitted that as per his instructions, the petitioner is ready to be transferred at any place of any nearby place of posting from where he can easily move to Dibrugarh for the treatment of his child. First of all, it is submitted that next para, it is submitted that the representation of the petitioner dated 23/9/2024 no, not 23/9. Where is your representation?
Page number 18, Lordship.
18.
Annexure 2.
Representation of the petitioner. What is the date?
Date is
23/9/2024. Addressed to the Principal Chief Conservator of Forests was handed over to the Divisional Forest Officer and by a forwarding letter dated 23/9/2024, the Divisional Forest Officer has forwarded the same to the Chief Conservator of Forests. However, the said representation has not been acted upon. Next para. On a request of the court, the learned government advocate had contacted the office of the Principal Chief Conservator of Forests, and it is submitted that the said representation has not reached the office. Full stop. Next para. Accordingly, the petitioner shall perform. According to the petitioner shall submit a copy of the said representation dated 23/9/2024 to the office of the Principal Chief Conservator of Forests so as to enable the said authority to take a decision. Next para. Be that as it may, issue notice returnable on (28/10/2024). Requisite extra copies of the writ petition be served on the learned government council in course of the day. Next para. Along with the representation, copy of this order shall also be provided to the Principal Chief Conservator of Forests within bracket EF and CC, Itanagar. Full stop. On receipt of the next, you say, in the event the representation of the petitioner is received in the office of the Principal Chief Conservator of Forests on 27/9/2024, the said authority shall make an endeavor to dispose of the same within 10 days from the date of receipt of this such representation along with the copy of this order. Next para. Till the disposal of the said representation or till the next date of listing, whichever is earlier, the respondent shall not initiate any coercive action against the petitioner. Next para, list on 28/10/2024. Ask him no coercive action because he appears to be suffering from heart problems. Cyanotic, if it is correct, leads to certain complications.
Yes, sir.
But medical is something I read.
Your Lordship.
Medical is something I read. I'm almost up to date
Yes.
insofar as these medical terms are concerned.
Yeah.
I have some personal interest and therefore
Oh, yeah.
I read medical books.
Obliged.